సార్ నమస్తే.
ಅಪರೂಪದ ದರ್ಶನ.
ಹ್ಞೂ ಸರ್, ಹೆಂಗಿದ್ದೀರಾ ಸರ್?
ಫೈನ್. ಇವತ್ತು ನಮ್ಗೆ ಏನೋ ಬಹಳ ಲಕ್ಕಿರ್ಬೇಕು.
ಯಾಕೆ ಸರ್?
ನಿಮ್ಮ ದರ್ಶನ ಆಗ್ಬೇಕಾರೆ ಅಷ್ಟು ಸುಲಭನಾ?
ಥ್ಯಾಂಕ್ ಯು ಸರ್. ಹುಷಾರಾಗಿದ್ದೀರಲ್ಲ? ಓಕೆ ಸರ್.
Page-wise adjournment, list 1, page 3, serial number 6 to 10, page 4.
I beg to appear for serial number 15, Your Lordship. I may be permit to withdraw, Your Lordship.
Call from that.
3, serial number 6 to 10, page number
Serial
4,
number 15, Your Lordship.
11 to 15.
15, kindly may permit me to withdraw, Your Lordship, since
Which
both
one?
of them compromised and dissolved their marriage.
Sir, it is list 1, serial number 15, sir.
Yes, 15, my lord.
Then I have to file a memo or something, just
Please,
like
my
the
lord.
permit.
I'll file.
Yes, next.
Serial number 13, my lord. Serial number 13, appellant is passed away. So I have to bring the LRs of the appellant on record.
When he passed away,
No, in February, 6th of February.
it is submitted that the appellant is no more and they'll take steps. Does this matter after 2 weeks? Yes.
Page number 5, serial number 16, serial list number 2, page number 6, page number 7, serial number 16, my lord. List number 2, serial page number 7, 8, 9 and 10, page number 9, 11 to 16, page number 10, number 17 to 25.
Serial number 17, my lord.
17, my lord.
Matter is going to be settled, my lord. Interim order may be extended.
2 weeks time will be done.
Finally, 2 weeks time is granted. It is submitted by both the council that matter is likely to be settled. Yes.
Serial number 24, my lord. Petitioner
Serial number?
24, my.
Lordship,
Senior is not in station. Kindly have it on Monday, my lord.
Lordship, I appear for the respondent. I substantially argued that they chose a date on 19th. It was before a coordinate bench at Portal 20. I substantially argued. He recorded a partial order sheet also. And now again, they're taking,
You
they were
were
not
fine.
there on
We were
19th.
not
They're
present
not
before
there.
the court that day.
Uh-huh.
We were not present before the
No, anyhow, what is the reason for adjournment today?
senior is not in session, ma'am.
What senior for us? Let's see the file. How many times it was adjourned?
This is
Yes.
the first time only, ma'am.
Wait,
We are
number
seeking, this is the
nine.
first time only we are seeking, ma'am.
Last
Can
time.
you have it on Monday, ma'am?
We'll see.
My lord, serial number 16, I appear for respondent, I pray for 2 weeks' time. Senior father is admitted in hospital.
Huh?
Senior father is admitted in hospital, so I pray for time, my lord.
Serial number 16.
You wait for a minute. The court may allow your CP itself. Wait. If required, then
number
we'll
nine.
adjourn.
Page number 11, serial number 26 to 32.
Yes.
Yeah.
For the list.
Page 1. For dismissal, serial number 1, Harish Bandari for appellant. Yes.
Appellant is insurance company,
No, my lord, it's the owner's appeal.
owner's appeal. On 27/2/2025. As per the order sheet, it appears that the appellant, owner of the vehicle has not deposited the 50% of the amount. Further, the appellant did not care either to deposit the amount or to represent in that regard. Hence, the stay granted 26/10/2018 is deemed to be vacated. And further, as there was no representation, the matter was directed to be listed under the caption for dismissal. Today, when the matter is listed, there is no, even today, there is no representation on behalf of the appellant. Accordingly, the appeal is dismissed for non-prosecution.
For orders matter, serial number 2, Patel D. Karegowda for appellant.
Respondent.
AM
Appear for
Vintage.
appellant, my lord. I pray for 4 weeks' time, my lord.
Hmm?
I pray for 4 weeks' time, my lord.
Why? You want to argue it in 2033?
To type a translation copy, ma'am.
Huh?
Translation copy, to type a translation copy.
Translated copy to be filed. Passover, this matter has to be argued today. No translated copies are required. Yes.
Serial number 3,
Appellant counsel not has 10 days time to file
Ramesh
translated copy.
Kumar.
Every matter for translated copy. What is it? What is the copy that's required?
That I am proxy counsel not is not in station, not that. That's why he request me to seek for.
All 2015, 2013 MFAs. Why should we adjourn? Finally, let's this matter give some day.
Please,
Let's this matter tomorrow. Tomorrow is
plan next week in a date, Wednesday or Thursday.
look at as per the matters. Give a day. No further adjournments will be granted. And if
28.
Please,
the translated copies are not filed by that time, the appeal shall be dismissed on that ground. Yes.
Serial number 4, O Mahesh for appellant.
Lord, copies are ready, my lord, it will be filed today.
What are the copies?
Translation, my lord.
Translation of what?
Translation of, my lord, the relevant documents, my lord,
You're on liability.
yeah. And deposition also, my lord, deposition also there. It's ready, my lord, I'll file it today.
List this matter tomorrow.
Yes, ma'am. Serial number 5. That is B.
Requires translation copies, my lord. Since, my lord, the two
Where is
vehicles,
Pradeep?
That is B.
Pradeep, I have informed him that I'll take adjournment, my lord.
You that file.
Last time, my lord, they heard for some time, my lord, the lordship is directed to furnish translation copies.
This court has not passed such order.
Not this court, my lord.
What is, Insurance company is in appeal
Please, my lord.
on the
we shall
ground
see-
of liability.
On liability, my lord.
What is that? Yes, Pradeep?
This case challenging the involvement of the vehicle.
Hmm.
Initially, my lord, the FIR was lodged
Hmm.
by one eyewitness,
Hmm.
PW2.
Hmm.
Vehicle bearing number, my lord, KA 10-8991,
Hmm.
Mahindra pickup vehicle, which is involved in the alleged accident.
Hmm.
After lapse of 1 month, 8 days, again restatement has been given.
1 month, 8 days.
8 days. Stated that, my lord, the vehicle in which, my lord, KA 22 M6581 is involved in the alleged accident.
Hmm. KA 226581.
Yes.
Hmm.
Therefore, my lord, the initial vehicle which was given by eyewitness only, that vehicle might have no insurance and all, my lord. They have implicated our insured vehicle to get the compensation.
Hmm.
That is our case.
Let's see how it is dealt with by the court.
Please. Para 15.
11 not necessary.
There is a discussion, my lord. The final conclusion is, my lord,
Para 15.
15.
Eight.
RW1 in his examination in chief by way of affidavit has also contended that the vehicle bearing number KA 10-8991 was involved in the alleged accident. The vehicle bearing number KA 22M6581 was not involved in the alleged accident. RW1 in the cross examination has stated that he has not challenged the charge sheet. If the vehicle bearing number KA 22M6581 is not involved in the alleged accident, the second respondent would have challenged the charge sheet filed against the driver of the said vehicle by contending that the said vehicle was not involved in the alleged accident. After coming to know that know about the said facts, but no such efforts has been made by the respondent number 2 in this case. Further, the police officials after conducting a detailed
Oh.
investigation.
Police have filed a charge sheet against that vehicle.
That vehicle. That vehicle.
That vehicle is insured with you.
Please, my lord, that vehicle is not dispute, my lord. Only because of, my lord, the MSCT coming to the conclusion, I have not challenged the charge sheet.
No,
On that
it's not
basis,
even
my lord-
about challenging the charge sheet.
Please, my lord.
No, as per the evidence, on that particular day, a vehicle is involved in the accident.
Vehicle involved, the vehicle number has, an eyewitness who has given a vehicle number.
For that reason, no, initially one number is given.
Please,
Later, for whatever reason, the police on investigation, prima facie, the charge sheet shows that that vehicle is involved in the accident.
please, my lord, that.
So what is the evidence from your side to say that this vehicle is not involved? From their side, they have
Officer-
the charge sheet.
Officer of the company has been examined, relying upon the complaint, my lord, the
Apart from
complaint
that,
and
the other
FIR.
evidence.
Apart from that, my lord, you have not laid any evidence, my lord.
Yes, please.
But
go.
prima facie itself shows that, my lord, the vehicle in which earlier.
It requires, no, if you're saying that, it requires some more evidence and proof from your side.
I have to summon the IO, my lord, that has not done.
Agreed with orders passed in MVC number 27 of 2012 dated 23rd June 2016. The insurance company is before this court. The claim petition is filed seeking compensation of an amount of 6,20,000 for the injuries sustained by the claimant in the road accident. It's a case of the claimant that on 22/5/2008 at about 12:15 p.m. The petitioner along with her sister and others were proceeding towards Rampura Government Hospital by walk on the left side of the road. For getting for the for getting administration of polio drops to the minor child. At that time, Mahindra pickup vehicle bearing registration number KA 22M6581 driven by his driver came from opposite direction and dashed the petitioner, and he sustained the injuries. On the issue of on issue number 1, with regard to whether the petitioner has proved the rash and negligent driving, that he has sustained injuries in the motor accident as the motor accident as it was hit by KA 226581. It's a case of the insurance company that when the eyewitness has given a report, the vehicle number is KA 10-8991. After 1 month and 8 days, the police have changed this number to KA 226581. Basing on this, the insurance company contended that the vehicle is not involved in the accident. And as the first vehicle was not having the insurance policy, this vehicle is implicated in the accident to get compensation. This vehicle is involved, is insured with the insurance company. The tribunal has negatived the said contention of the insurance company, stating that the police, after a full-fledged investigation, have filed a charge sheet against the driver of KA 226581, KA 22M 6581. The insurance company has not questioned the said charge sheet. As such, the court has held that the said vehicle is involved and the accident had happened because of the rash and negligent driving of the driver of the said vehicle, and granted compensation of an amount of rupees 66,896. Next, learned counsel appearing for the insurance company has reiterated the grounds that are taken before the tribunal and submits that the particular vehicle, that is KA 22M6581, is not involved in the accident. And the question of insurance company challenging the charge sheet will not arise. And they know there is no necessity for the insurance company to question the charge sheet. It is submitted that when the application is filed under section 166 of the Motor Vehicles Act, the burden lies on the claimant to prove the accident and the involvement of the vehicle. It is submitted that in this case, the claimant has failed to prove that this particular vehicle, that is KA 22M6581, is involved in the accident. As such, the order requires to be interfered by this court. Next, parallel counsel appearing for the respondent claimant submits that the police have conducted a full-fledged investigation, and thereafter they have come to the conclusion that the vehicle involved is KA 22M6581, and they have also filed a charge sheet. The evidence by filing the charge sheet and the police records, they could establish before the court that the said vehicle is involved. If the same is denied by the insurance company, they have to put forth, they have to adduce the evidence. And in this case, no such evidence is adduced by them, except examining the officer of the insurance company. It is submitted that the tribunal had rightly considered and passed an order, and no interference is required with the well-considered order passed by the tribunal. Next, having heard the counsels on either side, peruse the material on record. There is no dispute about the fact that the PW2 high witness has initially given the number that is KA 10-8991. Thereafter, the police have registered the complaint and they have conducted an investigation. In the investigation, they have come to the, they found out that the vehicle that is involved is not the one which the PW2 has mentioned, but it is KA 22M6581. And after full-fledged inquiry, they have filed the charge sheet. Now it is the case of the insurance company that the vehicle is implicated in this case, and it is not at all involved in the case. If that is the stand of the insurance company, they have to prove the same by adducing cogent evidence. Except relying on the initial FIR, they have not adduced any other evidence, or they have failed to prove the same. In that view of the matter, tribunal has rightly held that the insurance the vehicle is involved is KA 22M6581, and the insurance company is liable to pay the compensation. And this court finds no reasons to interfere. The amount in deposit shall be forthwith transferred to the court. Yes.
Cell number 6.
Much obliged.
Jonathan Reddy for appellant. Endunta Swami for R1.
Taxi comes it to the appellant, my lord.
One number 2, copy of tracking memo is not being served.
I'll file it now itself. I will.
When did you file your wakalat?
Wakalat, my lord, last occasion also I have informed this court, my lord.
Why they are not serving the?
We have received only, my lord, LR application. LR application.
2017 appeal.
Now itself I have submitted.
Well, it's not question of serving now. It should have been served by this time. When counsel for the respondent submits the appeal memo is not served and the counsel for the appellant has served the same. Delay of 764 days will condone. Delay of 64 days will condone.
64, I have no objection.
IN number 1 of 17 is filed to condone the delay of 64 days in filing the appeal. For the reasons stated in the accompanying affidavit, the delay of 64 days is condoned. Registry is directed to call for the TCR. This is matter for final hearing.
Matter may be,
Admit.
my lord, Lok Adalat can transfer.
Please, my lord.
Both the counsel submit that the matter may be referred to the Lok Adalat. Registry is directed to place the same. Yes, next.
Cell number 7.
I'm for respondent number 1, my lord.
I'm for the appellant, my lords. This is a case of injury, my lords. Claimant's appeal for enhancement of the award amount, my lords. There is a delay of 166 days, my lords, in filing the appeal.
Yes, madam.
It may be
Will condone-
condoned. my lord. Condoned.
Will condone the delay.
Yes, my lord.
IA 1 of 18 is filed to condone the delay of 166 days in filing the appeal, same for the reasons stated. The delay is condoned. Registry is directed to call for the TCR.
Please, my lords.
This is matter for hearing. Admit.
It may be taken now, my lord.
We will first complete from 12 to 15, 16, then we will look at 17. Yes, next.
Cell number 8. Sripad V. Shastri for appellant. H.P. Chandrasekhar.
No representation on behalf of either of the parties, either of the councils. This is matter for dismissal tomorrow. Yes, next.
Number 9. Sri Harsha A.K. for appellant.
Appellant in MFA 910019, your lordship. There is 80 days in delay in filing there.
I number 1 of 18, same delay is condoned. TCR is already, it's awaited.
Yes,
My lord, death case.
After
my lord, I
receipt of
think,
TCR, this is matter for final hearing. Admit. Next.
Cell for admission matter, cell number 10. Gururaj Shetty K.
I'm for
for
appellant.
appellant.
Is the connected matter, my lordship, already settled and before Lok Adalat. Kindly refer to the
Submitted that the connected matter, what is the number?
That is-
listed. It is also
7116/2004.
So and so, write on the paper. So and so is settled.
Is on
I
list.
appeal for insurance.
6 of 2014
Insurance.
is settled in the Lok Adalat. Registry is also directed to place this matter for the Lok Adalat. Yes, next.
Cell number 11. Chandrasekhar R for appellant.
Case of injury, my lord.
Hmm?
Case of injury, my
respondent. So there's additional documents.
lord, additional documents, my lord, driving license extract produced, my lord, along with the
Who appears with
application.
respondent?
S. Sri Shaila.
Lord, I appear for the respondent, my lord. Lord, company is not admitting that document. It is a matter of proof. Matter has to go back, my lord, for that purpose. If they are very much on that, they
What
say
is
some
that?
driving license.
Let's
One,
see
this
that,
is not a owner's appeal.
again-
Owner has not questioned.
Order 21.
After investigation, police have filed charge sheet against driver of the vehicle, my lord. There are no driving license, 3-1 charge sheet, my lord. Then after inquired me, the driving license is there. I have produced the real extract, my lord.
Well said.
LMU license, my lord. Vehicle is LMU vehicle, my lord. Date of issue, my lord. 30.
Why, what is the proof? Why
There's
can't
no
you
proof.
verify this?
There is no, my lord. The owner has not come up in appeal. He has admitted.
No. This is a driving license. Why can't it be verified?
My lord, our investigator went to the RTO and they say that there is no such thing. So, my lord, the company is in a fix whether to admit or not. So it is a matter of proof. Owner has not. We called the owner also. Owner is not responding. The driving license is not produced by the owner. Owner has not filed appeal also.
This document is issued by whom? Driving license is issued by whom?
They have to examine the RTO and officially it has to be proved.
So why should it be produced by the owner? Why the authenticity of it has to be doubted? It can't be verified without examining anyone. You can't have it from the the department, any application under the right to information.
We'll once again write a letter to company.
No, why like 2016 and when is the accident? The MBC of 2014. What is the point in remanding the matter now for such a small issue? Please get instructions. The application under 21 Rule 97, Rule 21 or 21 Rule what is filed.
3 weeks time. will be given, my
An
lord.
application for additional evidence is filed with the appellant. If any of the respondent, insurance company, have they filed their objections?
No.
No, my
Shall
lord.
file their, they have filed the license issued by the transport department. If they are disputing the same, they shall come up with the necessary objections, or else, but on the next date of hearing, the matter will be heard on the merits. Place this matter on
3 weeks, my lord. I'll send to the
16th of
RTO
April.
and
16th of April.
much obliged. I will do that.
Till number 12. Babu M for appellant, AM Venkatesh for respondent.
Respondent, my lord.
Where is the counsel for the appellant? No representation list for dismissal tomorrow.
Please.
Till number 13 adjourned. Till number 14.
I am for the respondent, my lord. The case.
Nagaraj Hegde.
Case of injury, my lord. Case of injury. Lord, the tribunal has not awarded any compensation towards future earning capacity.
It's a case of injury.
Yes.
How much is the amount claimed?
Amount claim is, my lord, 11 lakh.
How much is awarded?
Awarded is, my lord, 1,50,800. Out of
Lakh?
1,50,800.
Any disability?
Disability 14% to the right limb.
So what is it to the whole body?
Lord, what happened, the fracture of both bones of right forearm. Lord. He was a student as on the date of accident. He was continuing his study in diploma. Lord, during the pendency of the case, Lord, he has completed his diploma course. Lord. But though
So
is
if you have to, if you want, if the court has to grant the future loss of future earning, you have to establish that that injury has an impact on your future earning.
definitely that has been
Please
proved.
come to that particular
Lord, it's in Kannada.
discussion.
Entire portion is in Kannada. Ma'am.
Huh?
All the document copies in Kannada.
Place this matter on 17th of April. By the time the translated copy of the order has to be, the impugned order shall be filed.
Maybe, Lord, the records also may be required. Lord, because
In the meantime, the telephonically, the registry is directed to call for the TCR by then.
much of it.
Yes, next.
Till number 15. D. Vijay Kumar for appellant, KT Gurudev Prasad.
I am for the appellant, my lord. In the connected appeal, my lord, I have not received the copy of the appeal memo and also not filed the
Court
Wakala.
notice has been ordered.
Huh?
Court notice has been ordered. Notice has been served. Even afterwards, I have given a copy to him, but I have not taken the acknowledgement signature.
I will file the wakalat, my lord.
His first appeal is by him only.
Yes, it is my appeal.
This is matters for.
I will file the wakalat, my lord. I will get the wakalat and
Then
file it.
will 270, this delay will condone and post it for final hearing.
Yes, my lord, without interest. Without
Yes.
interest.
I number 1 of 21, so delay is condoned on the condition that he will not be entitled for the interest for 278 days. Yes, next. The admit post for final hearing.
For reporting.
Without interest, my lord.
Yes.
Till number 16. For reporting settlement, Vasantappa for appellant.
Lord,
Yes, Krishna Kishore.
I represent the second respondent, my lord.
Matter
Lord,
settled before the Lok Adalat.
Lord, on 28/2/2025 itself, four of us have reported the matter to the Lok Adalat, settling the claim for 5,50,000 rupees in a lump sum amount. The same was listed in the additional list, and they are badly in need of this file, so that they can show the disposal.
They can go to
It has to be, the file has to be sent to the Lok Adalat section, so that they will.
submitted that the matter is already settled. And the registry is directed to send this file to the local authority.
Correct.
Case number 2. For dismissal, sale number 1. Virupakshaya PH.
This we wanted to withdraw because there are 8 regular appeal matters in the trial court and 1 regular first appeal in high court pending, two regular, total 10 matters disposed of with 2 common judgments. In the regular first appeal, an order is already made, not yet pronounced, dictated, that the matters which are pending before the high court to be transferred to the trial court. In that instance, we wanted to withdraw this. However, the matter is posted for Monday. Till then, opportunity may be granted for us to make submissions post Monday, my lord. This we want to withdraw. As a petitioner, I want to withdraw, but we are waiting for the orders which are pending in the RFA matter, my lord.
What is the connection? I'm not able to understand.
My lord.
You have a stay in this?
Yes, my lord.
Hmm.
The trial court matters are stayed now, regular appeal.
So from 2019 till now, the matters are stayed.
Yes.
Why you want to withdraw it now?
My lord, there are 2 regular first appeals filed by the plaintiff, who is the unsuccessful plaintiff here in High Court, which are pending. There we are, my lord.
You are
I am the respondent in that. I am not
the defendant.
I am the defendant. So in the regular first appeal, where I am the respondent, arguments were canvassed, where the lordships were convinced the matter, regular first appeal matter, to be transferred to the RA, regular appeal in the trial court only. The entire 10 matters be adjudicated at the regular appeal. Here we filed this appeal that the 8 matters which are pending in trial court be brought to here in High Court and disposed of together.
So the order is dictated.
Yet, my lord, it's not yet pronounced. Open court, the order was made, observations were made. It is not yet pronounced. It is posted on Monday.
This matters on Tuesday.
Obligation. There are 8 matters in this month. Obligation.
Next. Sale number 2. Sale number 2, Shivaramu HC. Petitioner.
On 23/20/25, when the matter came up before this court, there is no representation on behalf of the petitioner. As the matter is listed today under the caption for dismissal, today also there is no representation. Accordingly, dismiss for non-prosecution. Yes, next.
Sale number 3, Puneet C.
I have filed a memo, please, my lord, the respondents, my lord, they may be dispensed with the notice. Why? Because they are not yet been served with the notice before the trial court. I'm sorry, they are placed ex parte, please. I filed a memo.
Memo is filed seeking dispensation of notice to respondent number 3 to 7, 9 to 11. And they are as they are placed ex parte for the trial court. The memo is taken on record and notice to them is dispensed with at the risk of appellant. So with that, the service of notice is.
Service of notice will be
And
complete.
you're ready to argue?
Please, ma'am.
Yes, argue.
Lord, synopsis for a moment, please. Along with the
This is
petition.
matter tomorrow. This
Lord,
is matter
tomorrow I'll
tomorrow.
not be in station.
Monday, this is matter on
Tuesday, may I request?
Tuesday, notice to, yes, this is
Order.
matter on Tuesday.
Please.
Sale number 4, Vijay Shetty B.
No representation.
Yes, Commissioner, in this case, I will take a first steps today. I will take.
What steps you will take?
First steps, for fresh address will be given today. I will.
Take notice on the counsel appearing before the hand summons, before the trial court.
I will take.
Then counsel the petitioner shall take out hand summons on the counsel appearing before the trial court and shall file a memo to that effect by 8th of April, or else the petition shall stand dismissed.
And extension of interim order. And extension.
Is it extended on the last occasion? Take the file. Not extended. It's not there. Even before that also, right from 3/7/2024, it is not there. Where is the stay? When is the stay granted to you? It's an absolute stay.
16/8/2023.
Stay is already there. No need to extend it. Yes.
Serial number 5,
Post after service of notice,
Petition.
an R3 and R5. Yes.
number 6,
Date to be fixed.
After service of notice on them, it will come. Yes.
serial number 6, Kumar Ram,
Appear for the petition, my lord. Take first steps and I may be permitted to take notice upon the counsel appearing in criminal.
Same
miss.
hand summons. It shall be, memo shall be filed. What is the date given in the other?
8/4.
8/4.
My lord, I may be permitted to take summons upon the counsel appearing in criminal miss, my lord. Criminal miss. There's an MC pending in Ramnagara. I'm seeking that be transferred. Criminal miss is filed by me in Bangalore. So I may be permitted to take out hand summons of the counsel appearing in the court in Bangalore.
Criminal miscellaneous CP.
For maintenance, my lord.
How CP is maintainable?
No, I'm not seeking. I'm seeking MCB transfer to Bangalore.
Hmm.
And I have filed a criminal miss in Bangalore. So I may be permitted to take out summons upon the counsel appearing in.
A petition is permitted to take hand summons on the counsel appearing for the respondent in criminal miscellaneous number
109 of 24.
109 of 2024 before the,
MMTC2, MMTC2, my lord, Bangalore.
write it and give it.
Please,
to her.
please.
Yes.
serial number
And a memo to that effect, same by 8th, or else the stay granted by this court stands vacated.
Interim order to be extended, ma'am.
Look at it. If interim order is there, then extend. Yes.
serial number 7, Ajay Jain,
Lords, there's a office submission regarding discrepancy in the name. My lords have filed an affidavit. Along with that affidavit, produced the death certificate. Death certificate shows the name as Padma Bai. Now, my lord, she was also known by the name as Sundarama. Suit for partition. So her maiden name was Sundarama. After marriage, she's changed the name.
Whatever that is there in the cause title before the trial court.
Yes,
same
that is,
thing.
I put that name. But the problem is that the death certificate, which because she's passed away, the death certificate shows a different name. So I produced the affidavit filed by the son in that suit, saying that her maiden name was this.
Let's see.
Page 6, my lords, may to see, that's the death certificate. IA number 7, my lords. My lords, may to please look at IA number.
Yes.
My lords, may to please peruse page 6, my lords.
Hmm.
Page 6, my lords will see that the name is shown as Padma Bai.
1 minute.
Sorry, minutes.
Page number 3 1. What is the number? It is not 6 and 7. It runs into 311, 312. That's how the page numbers are given.
My lords, it's after the verifying affidavit. Minutes. After the I'm very sorry, minutes. After the verifying affidavit. Minutes. Document number 1.
Verification affidavit is filed.
Yes, next page, ma'am. Immediately after that page, ma'am, is the death certificate.
Death certificate.
My lords may see the death certificate. Name is
Padma
shown as
Bai.
Padma Bai. My lords may to peruse, turn over to the next page, my lords. My lords, it's an affidavit filed by Sridhar Talur Venkapparao, aged 54 years, son of late Venkapparao and TV Padma Bai TV. My lords, see that, my lords.
A form that my mother's name in our Aadhaar card
Ah.
is mentioned as Padma Bai TV. That in my mother's maiden name is Sundaramma. But after her marriage, my mother's name is changed to Padma Bai TV. Hence, I do declare that my mother's name as Padma Bai TV and Sundaramma belongs to one and the same person.
Yes.
That is my mother only. Retain my mother's name as Padma Bai TV in all her correspondence, records and documents. And in the suit, what's her name?
Sundarama, my lords. Suit it's shown as Sundarama.
Who are the parties in the suit?
My lords, I'll explain. My lords, there are two suits here, my lords.
Hmm.
One is, my lord, suit filed by me, my lords, which is OS 737 of 2022. 37 of 2022.
Will you get that?
My lord,
The cause title?
my lords, page 97, my lords.
Hmm.
My lords, may to kindly turn over to page 98, my lords. Defendant number 4, my lords, is Sundarama. My lords, in the suit filed by Mr. Krishnamurthy, my lords, page 31. Page 31 also name is Sundarama, my lords. Page 31 annexure B, my lords. There are two suits I am seeking for my suit to be transferred to the suit place where this suit is pending.
31. This is filed by whom?
This is filed by my brother Krishnamurthy,
What is the relation between you and that Sundarama?
my elder sister.
Oh, elder sister.
My elder sister.
This is suit filed by your brother and the other one is filed by you.
Yes, ma'am.
Seeking partition.
Yeah, what happens, my lord, is that my brother, he only files partition in respect of 5 properties. The other remaining 17 properties, they have divided between my other two. My brothers have divided among themselves. They have not given any of the female heirs the share in the property. So I come to know when this suit is decreed. And this suit goes up on RFA. When RFA notice comes, I come to know all of these. I file a suit for partition where I have clearly disclosed that the suit is filed. Decree was also passed. Decree subsequently comes to be set aside by this honorable court on the ground that, my lords, none of us had filed written statements, and my lords, the defendant number 1, the contesting defendant, had not been given opportunity to file. The RFA judgment, my lords, will find at page 225. Now, when the matter is remanded back, my lords, I make a request before that court also. I say that, look here, I have also filed a suit for both have to be heard together. The division bench was of the view that this is not a jurisdiction vested under RFA. That suit is not before me. So therefore, you file an appropriate application under section 24 and you do whatever you want. So it gives me that liberty, and then my lords remands the matter back to the trial court. Now, my lords, I filed a CP.
Please, please come.
Sorry, ma'am.
The office has raised an objection with regard to the discrepancy in the name of the defendant number 4, Sundarama, in OS cost title to the name in death certificate shown as Padma by TV. Learned counsel appearing for the petitioner submits that 2 suits are filed by both the brothers, that is OS number.
No, one suit filed by me,
That's
one suit filed by, I'm sister.
The brother filed OS number 2430 of 2003 on the file of the additional city civil judge Bangalore, and the petitioner, who is a sister, filed OS number 737 of 2022 on the file of the principal senior civil judge Bangalore. The 4th respondent in the suit filed by the petitioner is Srimati Sundarama. In their suit,
Third defendant. She's third.
In the suit filed by the brother, that is OS number 2430 of 2003 or 8 it is?
3, son. 3, I'm very sorry.
She's shown as, she's arrayed as 3rd defendant. Now, it is the case that the 4th defendant in the suit, that is the sister Sundarama, died, and they filed the death certificate and the LR petition to bring the LRs on record. That is IA number?
7 minutes.
IA number 7. It is submitted.
5 to 7 minutes. I set aside abatement also.
That IA number 7 is filed. It is submitted that along with the IA number 7, the petitioner has filed the death certificate where her name is shown as Padma by TV. Along with the certificate, an affidavit that is filed by the son of the 4th respondent, who has stated that her name is Sundarama, and in the Aadhaar card, her name is shown as Padma by TV, and you would like to retain the mother's name as Padma by TV. Basing on this, Land Council submits that the Padma Bai and Sundarama is a 4th defendant, and as such the office objections may be overruled. This court has perused the affidavit that is filed, and also concerning the relationship between the petitioner and the respondent being the sister. The office objections are overruled. notice needs to be ordered. in this.
May I
Notice
request
line
for
number 7.
permission to serve the counsel in the lower court?
Registry is directed to issue notice. In addition to that, land counsel for the petitioner is permitted to serve the notice on the counsel appearing, who was appearing for the fourth.
No, all.
Who was for all of them, only one.
Oh, no, my lords, there are more than 15 lawyers.
The counsels appearing before the court below for the respective respondents. List this matter on 21st of April. By the time a memo shall be filed before the court. Yes.
Cell number 8.
Kindly, my lord, I am for the appellant, my lord, in both the appeals, my lord. Kindly, week's time, my lord, I'll only have to file the acknowledgement before the court, my lord. One of the appellant is not keeping well, my lord. I'll place it before the court, my lord.
Give the order sheet. There are no interim orders by this court.
Not interim orders, my lord, only I'll have to serve the copies, my lord,
No,
that's
it's not
it.
serve the copy. 2018, when a matter is remanded, you have come before this court.
Please, my
Pending
lord.
MSA. Now we
Please,
are in
my lord.
2025. Even the remanded matter might have been disposed of.
No, my lord, it is pending, my lord. It is pending before the court, my lord. I'll place the order sheet, my lord,
Please
kindly
place the
weeks.
order sheet first before doing anything. We'll have
Okay.
this matter on Monday. First to place
Not-
before this court, the order sheet. We'll see.
Weeks,
what has
weeks
happened.
time, my lord. I'll place it, my lord. Weeks time, my lord.
Wednesday. This matter on Wednesday. By the time the counsel
Thursday.
petitioner shall place before this court the order sheet of the trial court and what is the status of the case before the trial court.
Thursday, my lord. Kindly one time extend. Thursday, my lord. Thursday. Please, my lord.
Basing on that, we'll pass orders on that day.
Please, my lord.
If the matter is proceeding, we'll not hear this MSA of 2018 now.
I also don't know. Let the matter be remanded. I am not in that way, my lord. Matter is pending. Matter is pending. That is the reason I'm saying it will be placed before the court, my lord.
2018, nobody has stopped you from taking steps for issuing notice on the respondents. The
No, my
matter
lord,
is dismissed for default. The matter is recalled.
I had not appeared, my lord, at the time of initial NOC was given to my lord. That is the reason, my lord.
Please take steps. Thursday we'll see. This is matter
Please.
on Thursday. Yes,
Please,
next.
my lord.
Cell number 9. Arjun Rao for a petitioner. Atulyam.
Please, my lords, I appear on behalf of the respondent. There are 4 interim applications preferred. One of them, my lords, in light of the urgency, is an application for refund of security. Our vessel was arrested by an ex parte order in Admiralty jurisdiction by a lordship's court, suppressing material facts. And my lords, on a completely without satisfying the test as required under Section 5 of the Admiralty Act. And we were forced to furnish, my lords, a security of 15 crores. We furnished a security of 15 crores deposited in your lordship's court to release the vessel because, my lord, it has drastic consequences. Therefore, this application was preferred to, my lords, vacate the order of arrest. If my lord sees the order sheet, the conduct of the petitioner or the respondent in my eyes is deplorable. 2 of, my lord, 3 orders direct of your lordship's court, my lords, have been violated. The first order, my lords, was directed them to file a reply, my lords, by the 2nd of March, not filed. Then, my lords, they were directed to file a reply and matter was posted, given the fact that, my lords, we come from, my lords,
When
outstation.
was the order of arrest was passed?
Order of arrest, my lord, the first order of arrest was 24th of July 2024. Security was, my lords, deposited and vessel was released by the order of 5th of August 2024.
Hmm.
Interim applications were preferred and served to them in January 2025. And, my lords, of course, we are deliberately knowing fully well that, my lords, we come from outside. Replies have been served to us today morning, where we are prepared to, my lords, go on with our interim application, my lords, for vacating the order of arrest.
We'll hear it at 2:30.
My lord, I'm extremely open.
If I just may make one submission, their application to vacate they have filed. They are saying arrest is wrongful, that arrest should be vacated. The order where they have sought release of the vessel, if my lords takes that order, it is subject to, and they have agreed to be subject to that condition, that this is without prejudice to rights and conditions, and all rival contentions shall be kept open to be decided by this court at the final disposal of the petition. My lords, my petition itself is for arrest, which is a security for my maritime claim. Now they're asking for vacation of that arrest. That would be in effect determination of the petition.
No, once they are before the court, whether there is any what is the on what ground you're seeking, whether there are reasonable grounds to arrest or not, we have to see.
That's correct.
Yes.
I'm extremely obliged.
Yes,
2:30, my lords.
Yes, 2:30.
Extremely obliged.
Cell number 10, PM Mohan Kumar.
There are two appeals, madam. And in one appeal, they have excluded the delay that should be excluded due to lockdown and COVID-19 pandemic. In the other matter, they have not excluded. That's the reason I'm filing memo to that effect. Right? Out of the first matter, they have shown delay as 1,487 days. The closure period of court and Supreme Court notification, dismissal court notification has not taken into consideration. That is to be taken into consideration.
How can it be split like that? You have that it's not your case that because of the COVID you have not filed it. When you're filing it in 2024, how the COVID period will come into
I have
your
explained
rescue?
in my application also, affidavit also.
It
the
will
final-
come to your rescue. You should have, if you have filed it immediately after that, we could have considered.
Yes, madam.
Not in 2024. COVID was not there till 2024.
No, madam. The notification says
Let's
that,
see.
that period has to be excluded while computing the delay period.
Not computing, for example, if you filed it in 2022 with a delay,
Yes,
so that period would be excluded. You are filing it in 2024.
madam.
But why should those can be considered? That's not the notification.
Madam, I'll convince this court, madam, that while computing the limitation period, the date from 15/3/2022, 28/2/2022, those days to be excluded. If those days are excluded, delay will not be like 1,400 days. That's my submission, madam. And I've explained in my affidavit what exactly the reason for me not approaching the court seeking announcement of the compensation. It's the land loser supply.
No, somebody will come to the court in 2030 and say, so I have to file an appeal in 2020. So in between the whatever is pandemic, as per the Supreme Court circular, so exclude the 2 years, and from there on my limitation starts running.
But
It can't be that way.
I agree with that
can't be
approach
that
cannot be accepted, madam. My respectful submission is, madam, this is the land losers appeal seeking announcement of the compensation, madam. They need to arrange this court fee and all.
Then why the court will be will be
Yes, ma'am.
condoning the delay. But however, you can't have the cake and eat it too.
But I explained in my affidavit, madam, the reasons for not filing the appeal in time.
This circular will not come to your
Yes,
rescue. And let us see your reasons.
Yes,
What are the
please,
reasons you're
please,
stating?
please. And this land losers appeal seeking announcement of the compensation, madam. And in my
Affidavit.
yes, madam, please. In my affidavit, I stated that first, madam, the first appeal filed before the district court, and after dismissal of that, my appeal before the district court and the award copy.
IA number?
IA number?
Yes, one.
Yes, madam.
One of them.
Have you filed your objections to this?
Yes, your lordship, I'll file objections.
Not will file. Yes.
Yes, madam.
So both appeals, one is for announcement of 2.5 quintas
Is it, part of that batch?
Yes, Your Lordship.
Who is the beneficiary?
Beneficiary is not arrayed as a party before the trial court as well.
What
Yes.
is that?
Yes, Your Lordship. Beneficiary is not.
Who is the beneficiary?
Beneficiaries, my lord,
Only special land acquisition officer are made. R1 as a special land
Egichi
acquisition.
Reservoir project, Egichi Reservoir.
Egichi Reservoir.
It's
So
a
this
part
is
of,
not part of that batch.
No.
there are other petitions, my lord, where under the Summit Court has enhanced the compensation, whereas the
Who is
beneficiary.
Who is the beneficiary? Who appears for the beneficiary?
My lord,
What are the other matters where Mr. Prashant, BR and are appearing?
That are from Tumkur, Your Lordship. This is his Asan
That's
case.
what I'm asking.
Hmm.
It's not part of that. It's a different acquisition.
Different. It's an Egichi Reservoir.
Then file your objections. The I number 1/24 is filed to condemn the delay of 1487 days. The counsel appearing for the respondent seeks time. Filing objection, this is matter after 2 weeks. Yes,
Number 11.
same way.
same. 12,
Number 12.
I appear for a respondent in this.
who appears for the appellant?
Gangadharappa AV.
Delay of 2 days in filing the appeal.
I number 1/24 is filed to condone the delay of 2 days. For the reason stated, delay is condoned. Yes, let's smart for admission.
AGA take.
Yes.
Number
Next.
13.
That's for the appellant. There is an IA for dispensation for the production of the certified copy.
You have not filed the photocopy.
Photocopy
also.
is filed, my lords. It is
Why it shows photocopy not filed?
page number 20, my lords, is the
Page number?
20, my lords.
Page number 20.
Please, my lords.
You are questioning the judgment in RA number 57.
Please, my lords.
You filed the judgment in RA number 56.
Lords, both are there. It's a common order, a common judgment.
Where do you get that?
The next page, my lords. Page number 21. Because the suit and a counterclaim was filed.
Where is the IA for dispensation? I number 1/2/25 is filed seeking dispensation of the filing of the certified copy of the judgment in OS number in RA number 57 of 2022. The accordingly I is allowed in the production of the same is dispensed with for the present. Yes,
My lord, there is some urgency in the matter. It may be posted tomorrow for admission. my lords.
tomorrow. Let's this matter tomorrow for admission.
Much.
Till number 14.
14, I appear for the petitioner. The last date of hearing, 7th, the office objections were overruled. And the court had issued citation and it was recorded. I had given the newspapers also. But then when I went back to the office and checked,
It's not there.
it was not there and I was told to file an application for citation. So I filed an application.
it on that day?
Objections are raised on the application. Now objections are raised on the application. The lady is a widow who's suffering. Otherwise the shares will lapse, my lords. That's why,
Which daily you said?
my lords.
Which paper you said?
I had said Indian Express as well as Kannada Prabha Bangalore edition.
The citation is issued and the
Lords,
petition
I
shall
may be
take out
given
notice.
time till 28th to take out and in my application, I've also enclosed the draft
In
paper publication.
Indian Express,
Indian Express
uh,
and Kannada Prabha,
uh,
Bangalore edition.
Bangalore edition on or before?
It will be before the 28th itself, and thereafter 30 days may be fixed so that before the vacation
On or
itself, I'm able.
before 28th of April,
Not 20, I'm saying 28th of March itself.
28th of March.
And then thereafter 30 days may be fixed for the hearing,
It's a
so that
matter.
before the vacations itself.
This
I
is the
may-
matter on again 20th,
30 days, my lord.
28th of April. Yes, next.
28th of
15, 28. Then for admission.
April 2nd.
15.
Yes.
I'm sorry, my lord. One CP matter, my lord, they dismissed for default, it appears one
Uh-huh.
CP. List number 2, my lord, I was held up in the other court.
Uh.
I'm seeking transfer of the petition, your lordship. List number 2, serial number 2, my lord. I was held up in the other court, my lord, in first matter itself, your lordship. That's
Call it at 2:30.
please, lord.
Yes, next. It's 15,
Cell number 15, NR Nayak.
no representation for dismissal tomorrow. Yes,
Cell number 16, Somnath. For 2 weeks time.
let's see, you appear for,
Respondent. I
Your
pray for
lordship,
2 weeks time.
it's a
my lord.
petition filed by?
Filed by husband, my lordship. It's seeking transfer of matrimonial case from Dodbalapura to Mandya, my lord. He's seeking
Developed
transfer
to,
Dodbalapura to
To
Mandya,
Mandya.
civil.
on
senior
what
division.
ground?
On medical grounds, my lord. He's suffering from several medical issues and is suffering both hip joint pains, my lord. He cannot travel more than 15 to half an hour. He cannot sit on the one place and even in the car, my lord. He has also diagnosed for MRI scanning and other reports also been produced before the honorable court. On these medical grounds, he is seeking for transfer.
How much is the distance between both the places?
It's around 144 kilometers.
Then how the wife will travel? Their children in the,
No children, no issues.
how will she travel for not 5 kilometers?
Only on the medical ground he's praying, my lord. And the stage is for cross-examination, further cross-examination of.
No, once the trial has commenced, question of transferring will not arise. That is one more ground. Even in other cases also,
kindly
even
see-
if the wife seeks transfer,
Yes.
once the trial commences, court will not transfer.
Kindly see the doctor's advice, my lord, page number 65, my lord. He has produced MRI report. The both hips was is a small impression.
You were appearing all through.
No, no. He's taking in Dodbalapura civil court.
No.
No, he has not
You were
appeared.
appearing all through. That's how now it is
No,
for the
no.
cross-examination.
Counsel is cross-examined.
Where are the docket, the proceeding sheet filed before the court? This matter on Thursday, by the time the learned counsel for the petition shall place before this court the proceedings of the trial court. Yes,
Cell
next.
number 17. 17 adjourned, cell number 18. Rangaramu B.
Case in which the respondent is already appearing before the court at
Please,
Mysore,
this case, sir.
and also.
We called on
Magistrate-
Wednesday, please. We called on Wednesday. The party has not given the affidavit yet. That we'll file it on before Wednesday after serving a copy. Please. Called on
This
Wednesday.
matter on Wednesday,
Please,
at the request of learned counsel for the respondent.
Please, ma'am.
And they
Yes,
are
thank-
already appearing before the family court at Mysore and filed the objection. And also tomorrow is there for cross-examination. She is appearing before the Mysore court, family court.
Is appearing.
It's not,
Appearing. I've got the document.
We'll hear it, finally we'll dispose it off on Wednesday. Yes,
Cell number 19.
First petition, my lord. First petition, my lord, 433.
Second petitioner, my lord, I am the petitioner, my lord. I am appearing for the wife, my lord.
so this, see,
There are two petitions filed, my lord, one by the husband, one by the wife, my lord.
433 filed by the husband, my lord.
CP 433 is filed by
Husband.
husband. You appear for the husband.
I am, yes,
And CP
292.
292.
by the wife.
Wife, my lord.
What are the cases pending?
My lord, so far as my lord, the wife is filed the restitution of conjugal, my lord.
Where?
In Davanagere court, my lord.
Davangere.
Davangere.
Husband filed?
Husband for the divorce, my lord, on the ground
Where?
of, in the Chitradurga, my lord. Further, my lord,
What is the distance between the two?
80 kilometer, my lord.
Hmm.
Further, my lord, wife also filed the two.
We'll ask the husband first. Why, what are the reasons for transfer?
My lord, he is working as a assistant professor.
Huh?
Assistant professor, my lord.
Assistant?
Professor.
Professor?
Sorry.
Huh.
Professor in SJM College, Chitradurga.
Huh.
And therefore he sought for a transfer of this petition under section 9 filed by the wife in Davanagere to Chitradurga.
That's the only reason.
My lord, apart from that, my lord, wife filed was the restitution of conjugal, my lord, it is pending before the Davanagere court. Apart from, my lord, there are two maintenance petitions, my lord, one DV Act and one for 125, my lord. The same is pending in criminal miss, my lord, 420 about 2024.
Davangere, understood. Yes.
Davanagere, and criminal miss 1232 about 2024. That is the
Children in the
oh,
wedlock.
children, my lord. So far as me is concerned, my lord, wife is, my lord, I am the second wife, my lord. So far as he is concerned, my lord, I am the second wife, my lord. Earlier he is married, my lord. So far as this petitioner, my lord, in 232, my lord, is the second wife, my lord. No children, my lord, out of wedlock, my lord. Further, my lord, I'm residing in the village, my lord, with along with my parents, my lord. No source of income, my lord. Further, my lord, I'm working as an household work, my lord. No income is there, my lord, for me is there.
Please come. CP number 433 of 2024 is filed by the husband seeking transfer of MC number 288 2024 pending on the file of the family court at Davangere to the court at Principal Senior Civil Judge and CJM Chitradurga. CP 292 of 2024 is filed by the wife seeking transfer of MC number 28/2024 pending on the file of the Principal Senior Civil Judge and CJM Chitradurga to the family court at Davangere. The facts of the case are the parties to the petition and respondent, the marriage was solemnized on 23/2/2020. When is the marriage?
That is, my lord, on 15/7 to 2022. 15/7, 2022, my lord.
15/7/2022. The husband is working as a assistant professor in Chitradurga. In view of the differences between the parties, husband has filed the MC seeking divorce on 23/2/2024. Wife had filed MC seeking restitution of conjugal rights on 10/7/2024. The wife had also filed 2 cases for maintenance before the courts at Davangere. And it is a contention it is a contention of the land council appearing for the husband that the husband is, as he is working as assistant professor in Chitradurga, it is very difficult for him to travel all the way from Chitradurga to Davangere, which is 80 kilometers. And as such, the case needs to be transferred to Chitradurga. Next para, land council appearing for the wife submits that wife has no source of income. She's residing in a village along with the parents. She has no means to travel from Davangere to Chitradurga, and she cannot travel alone. And it's difficult for her to attend the cases there at Chitradurga. It is submitted that the already 3 cases are pending at Davangere, and the husband has to attend, has to come to Davangere to attend these cases. As such, the MC filed by the husband seeking divorce may be transferred to Davangere and to be tried along with the petition filed by her seeking restitution of conjugal rights. Next part, having got the counsels on either side. Where is the material on record? Admittedly, 3 cases are pending at Davangere and 1 case for divorce is pending at Chitradurga. The reason that is stated with the husband that as he is working at Chitradurga as assistant professor, the pending petition MC for restitution of conjugal rights have to be transferred to Chitradurga. This court is not able to appreciate the said ground, or that cannot be a reason for this court to transfer the case from Davangere to Chitradurga. While when an application is filed seeking transfer, court has to look at the convenience or oblique inconvenience of the parties and also balance the interest of both the parties. In this case, admittedly, 3 cases are there at the Davangere. Wife is unemployed and staying along with the parents. In the facts and circumstances, the inconvenience or if the case is transferred to Chitradurga, more inconvenience to the wife in those circumstances. This court is passing the following order. CP 433 of 2024, filed by the husband, dismissed, and CP number 292 of 2024, filed by the wife is allowed by withdrawing MC number so-and-so, pending on the file of Chitradurga and transferred to the court at so-and-so.
Cell number 20, Siddharth Suman, for petitioner, Nagaratna.
Appearing for the petitioner, my lords. My lords, the respondent's family had reached out to the petitioner stating the respondent's family had reached out to the petitioner for mediation, my lord. Matter might be referred for mediation.
May be referred, ma'am. Referred to the mediation.
Mediation, my lords.
Both the council submit that the matter may be referred to the mediation. They shall appear before the Bangalore Mediation Center on when? Any day next week, ma'am.
Next week or
Will
next week?
appear before the Bangalore Mediation Center on 24th March.
Please.
And the registrar judicial is directed to communicate the same.
Cell number 21,
Appearing for the respondents, my lords. My lords, we have recently filed our wakalat requesting for 2 weeks of time to file
Let's
objections.
see what are the reasons for the
Yes.
transfer. What objections will be there in there?
Millards, the matter relates
It's
to
filed by whom?
wife, Millards.
What is the reason for transfer?
Millards, now, if my lords can turn to page number 28, please, Millards. And next year D. Husband is a resident of Bangalore. Aadhaar card of the husband is filed, but he files the MC petition in Mysore just to cause inconvenience.
Then they need to file their objections.
Yes, please. And in addition to that, I have a child. Single parent,
You have an interim order?
I have.
The
I have no
council
objection.
appearing with the respondent submits that recently they have filed wakalat and will come up will come up with objections. List this matter on 9th of April.
Grateful.
Next.
cell number 22,
The wife has filed this case, my lord, for transfer of the MC from Nanjangud to Bangalore family court, my lord.
Distance?
No, my lord.
Distance?
She is in Bangalore only.
Wife?
Wife.
Please, notes, my instruction is that the matter is going to be settled, it may refer to the mediation.
It may be referred to
Both the
mediation.
parties submit there is a
At date?
likelihood of settlement. Both the parties shall appear before the mediation center on
Friday, my lord, 28.
Huh?
in Bangalore.
Mediation Bangalore, 28 at 3 p.m.
28th at 3 p.m.
please.
3 p.m.
District judicial is directed to communicate the same. Yes, next.
Cell number 23, Vijay Kumar PM.
For the petitioner, my lord.
I'm
Respondent
permitted to 2 weeks to file a application
Respond-
because,
Respondent file at
What
your.
for objections?
and you have got a document also.
Yes, for objections. And like the other case objections, give it a date. Yes.
Cell number 24,
Respond.
Anand Kumar. Balram ML for.
Give that.
Your Lordship, this is a civil suit. May I submit, Your Lordship?
1 minute. So the suit itself is not there.
Yes, Your Lordship.
Where are they? They were there in the morning.
They were there in the morning trying to take
No
time.
representation for the petitioner. List this matter for dismissal tomorrow.
Cell number 25,
I appear for petition in this case, my lord. The petitioner is a wife. She has filed this petition for transfer of MC case which is pending before the Bangalore family court to the Chikbalapur.
Bangalore to Chikbalapur.
Yes, ma'am.
Distance is?
Approximately
around 60
the petitioner residing in a remote place, Peresandra. It is far from approximately 20 kilometers far from Chikbalapur. So approximately it is 100 kilometers. my lord. She is having a breastfeeding child. It's a 14 months baby.
14 months.
Yes, ma'am. And she is a housewife. And she is totally depending upon the
Seriously,
earnings of the petitioner.
Seriously opposed to transfer this petition because earlier it was referred for mediation, DSL. In court premises, petitioner and her brother assaulted the respondent. Before that also, earlier also, she trespassed into the respondent house and assaulted. In court premises also, she assaulted.
Then was it brought to the notice of the court?
Yes, yes. I have filed a PCR and it was FIR was registered against petitioner and his brother. And also I have sought for CCTV footages, Your Honor. I wrote a letter to the registry of Honorable High Court of Karnataka and also to the Home Secretary. Your Honor.
What has happened to that?
There is no reply. Your Honor. It is in Kannada. Your Honor. I will translate and I will produce all the documents and FIR also. Your Honor. There
Then
is a
counsel for
serious
the respondent seeks time filing his objections. This is matter on 8th.
Published.
Till number 26. Case Ulkapur.
Petitioner. Petition filed by the wife, my lord, seeking transfer of MC number 388 of 24 from Shivamogga to Davangere, my lord.
Shivamogga to Davangere.
Distance is 115 kilometers, my lord. The wife also filed one petition in criminal miss number 1022 of 2000.
That the present petition is filed seeking transfer of MC, transfer of the MC from Shivamogga to
Davangere.
Davangere. It is stated the distance between the places is 115 kilometer. This is filed by wife.
Wife, my lord.
So, and so considering the submission of the land counsel for the petitioner, they shall be stay of all further proceedings. In so and so, the petitioner till the next date of hearing, the petitioner shall serve the hand summons on the counsel appearing by the respondent before the trial court. Say, if not, the stay and file a memo to that effect by 9th of April, or else the stay granted by this court stands vacated.
Till number 27.
First petitioner is the wife, my lords, seeking for transfer from Bangalore to Davangere, my lords. Approximately 280 kilometers, 6 hours drive, my lords. 280 kilometers, my lords, Davangere, my lords. 6 hours drive, my lords. His grounds is that, my lords, due to dowry demand, he sent me out of the house, my lords. I'm staying with my parents in Davangere, my lords. Now he's filed a MC petition in Bangalore. Subsequently, RCR he had filed and he's withdrawn it, my lords. He is the one who asked me to get out of the house, my lords.
Seeking transfer of the MC filed with the husband seeking divorce from Bangalore to Davangere, and it is stated the distance is 280 kilometers and it's difficult for the wife to travel. Same stay, hand summons, and you have to
Please,
file the memo by 8th or else
Please,
the
ma'am.
stay will be vacated.
Grateful.
Till number 28.
CP 70 stay order is.
Must have granted
Yeah,
earlier.
it was granted, ma'am. The same may be.
I think that is not a limited stay.
No, till the next date of hearing.
Let's see, if it is there, look at it. If it is there, extend it till the next date of.
Please, see, serial number 25.
Till number 28.
I'm appearing for the respondent number 2 in this case, ma'am.
Petitioner land is acquired. The formation of Yamavati Canal.
Same order you want like in the other matters, remand of the matter?
Not yet
That
remanded.
would be appropriate, my lord. This case, my lord, I have filed objection.
You're already a party in this?
Yes, yes.
Uh,
I have filed objection, my lord, in this case, wherein the payment has been made, my lord, with regard to the mango trees is concerned, my lord. I have taken up the stand, stating that there are about only 11 mango trees, my lord. Whereas my learned friend has received, that is the claimant has received 36 compensation towards 36 mango trees.
236.
Mango trees are
Mango trees.
only 11.
Yes, per the.
Only
Of 11,
Now he is asking
They
for
have taken-
enhancement.
Enhancement.
Enhancement of compensation for the 36 mango trees. As per the AMC report, my lord, there are 36 mango trees was there. There the 36 mango trees and 32.
Then we'll hear this matter.
Yes.
List this matter. Finally,
Date may be fixed, my lord.
give a date. Next, maybe in 22nd of April. Yes, next.
What? This case I appeal for the second respondent, my lord.
Lords, in this case also, my lords, I am seeking enhancement of compensation. My lords, the land, my lords, which is acquired.
These two matters. For
This
final
case
hearing
also same, I
on the
filed
same day.
objection.
22.
Same days, yes. 90 also, 30 also same? Yes,
On this also I'm appearing for the respondent.
yes, yes. Next.
51.
Yes, Mr. Mohan Kumar.
Cell number
Much.
I appear for.
So for enhancement of my lord compensation.
Yes, admit post for final hearing.
cell
Yes.
number 32.
But if notice is not, my lord, issued to respondent number one, I have to verify it, my lord, in the order.
What is that?
Notice to respondent number two, Emautic and,
Transfer R2.
what, my lord? 31, serial.
Mohan Kumar, 31, BR Prashant for R2.
Please, my lord.
Yes, 32.
32.
For the appellants, my lord.
Hmm.
IA number 2 for stay, my lord,
Hmm.
execution of the
Hmm.
decree of the appellate court, first appellate court.
Yes.
Here, my lord, the matter was remanded, though there was a clear admission.
No. What are the facts? What is the suit for?
Fact suit for possession, my lord, and mean profits. While answering the interrogatories,
You are the plaintiff or the defendant?
plaintiff, my lord.
Hmm.
While answering the interrogatories, these defendants categorically admitted that they are ready and willing to surrender the premises in favor of the plaintiff. On that admissions, my lord, the suit was decreed to vacate the premises within 30 days from the date of order. And a separate inquiry with regard to the mean profits was ordered. Against that order, they have preferred an appeal, wherein the appellate court, though there was clear admissions, my lord, it has arrived to a conclusion that on that admission also, the trial has to be conducted.
Let's see. Let us go to that finding. You're ready with the argument?
I'm not ready for final arguments. For admission and interim order, I have no objections. I leave it to this.
No admission for this small issue. We'll decide it.
Then my lordship,
Ask your senior.
kindly have it on Tuesday, my lordship.
Tomorrow?
No, my lordship. Tuesday or Monday. my lordship.
Tuesday.
Thursday, please,
Thursday.
my lordship.
We'll dispose it off on that day.
Please, ma'am.
Thursday.
Obliged.
Let's just matter on Thursday, the request of joint counsel for the respondent.
Please.
Number 3. Serial number 1. Number 3, serial
appearing.
number 1.
I'm for the appellant.
Second B for appellant.
The appellant is dead. Suit is abated. Kindly dismiss the appeal. Tell him.
Why you don't want to bring the LRs on record?
So injuries 2013.
The case of injury. Okay. A memo is filed stating that appellant has died during the pendency of the appeal,
407.
and it's a case of injuries. As such, the appeal may be dismissed as appointed. Accordingly, the memo is taken on record and the appeal is dismissed as a writ.
Serial
Yes.
number 2 for final hearing. R. Jaiprakash
For the appellant, ma'am.
GB Manjunath.
You are for the appellant.
Appellant.
Who appears as the respondent?
R. Jaiprakash appellant. GB Manjunatha for R1.
Passover?
Yes.
No, one short question, my lord.
No, you understand. Other side has to be there.
Let
So
me
shall I
take it
pass over?
Some other day, my lord. If your lordship, please.
I think you are insisting for this matter. Earlier also.
Allah, I earlier are present.
There is no
Since my present was not, my friend was not present, your lordship please to adjourn to today.
That's
Today also.
2:30 will take your matter.
I'll-
2:30. Even that day is not present. Then we will hear today. Even if he's not there in the afternoon, we'll hear it. Please inform him. Yes.
Serial number 3. PC Sitaram Rao for appellant. Chan Kumar K for respondent.
No representation for dismissal tomorrow.
Serial number 4. MC Satish HK, MC Umadevamma.
Same order tomorrow for dismissal.
Serial number 5. Suresh M. Latur.
I am for appellant, my lord.
Where is Mr. Palakshaya? For Passover? 2:30?
Yes, yes, my lord.
Yes, 6.
So serial number 6. M.R. Ira method for appellant R.B. Deshpande.
No representation for dismissal tomorrow.
Serial number 7. Harish Babu. P.B. Raju for R2.
Yes, tomorrow for dismissal.
Serial number 8.
I am for the appellant, my lord.
Suresh M. Latur.
There are
Where
three
is
connected
Suresh?
matters. Ready, my lord.
Passover.
Yes. Omay.
Just inform him, inform Mr. Mahesh. We'll take up in the afternoon.
Serial number 9. N. Gopal Krishna for
Paper,
appellant.
paper appellant,
What
madam.
happened to the insurance councils? Where are they?
H.S. Lingard.
Appearing for respondent number 2 in this case, my lord.
You appear for respondent. Yes.
Paper appellant. My lord, in this case, insurance company exonerate on the liability on the ground that auto rickshaw driver that had no valid driving license.
Yes, what do you say?
Yes, my lord.
Pay and
The
recover.
pay and recover, my lord.
And secondly,
you are
my
on
lord,
Date
that
of accident, he is not done.
You are on enhancement also?
please, my lord.
Yes,
Because
give that. What was the compensation that is granted?
my lord, total compensation granted 1,66,400.
1,66,400.
400.
Is there any disability?
Please, my lord. The treated doctor was examined, he assessed disability 34% to the limb and 12% to the whole body. Tribunal has taken 8%. And income taken only 4,000. Accident of the year 2014.
2000?
14.
2014 is 8,500.
8,500.
Tribunal has taken only 4,000.
So please come to that
Please.
table. Come
Please,
to the
ma'am.
table.
Table. Internal page 14.
What are the injuries?
My lord, injuries, sir. Fracture of
Fracture of right middle, third
fracture right
radius, ulna,
and
my lord.
ulna.
Wound certificate that the petitioner has sustained fracture of right middle, third radius and ulna. So we'll grant 40,000 towards pain and suffering.
Please,
Then medical expenses, no dispute.
no dispute.
Then how many days was in hospital?
He was close about mm, mm. We had 4 days, man. 4 days. 28, 1 to 24, 31.
Then
Underwent,
we'll grant 4,000.
please.
Loss of income during later period.
For 3 months, tribunal awarded 12,000.
Court had granted how much? 3 months.
3 months.
Already
Then
12,000.
8,500 into 3.
25,500.
25,500. Then future loss of income.
The medical officer assessed 12% disability.
What is 1/3 of this 34?
12%. So 36, my.
36.
Yeah, please,
We will take 12%.
please. Please, man.
Doctor has, it is to the whole body 36%.
The limb, 36.
12% to the whole body.
Whole body 12%.
So 8,500 into 12 into what is the multiplier?
Multiplier,
What is the
16,
age?
16, my.
16, my lord, 16. Multiplier is
In
taken 16.
31 years.
12. comes to 1,95,840. That's it.
Please.
Legal expenses, 10,000.
Amendment is not has been granted, madam.
For that, plus 10,000. Comes to 3,40,340.
Please.
The present appeal is filed by the claimant, agreed with orders passed in MVC number 278 of 2014, dated 10th April 2015, where the insurance company is exonerated from the liability and granted compensation of an amount of rupees 1,66,400. The case of the claimant is that on 28/1/2024 at about 12:45 p.m., he was crossing the main road near Clock Tower towards KSRTC bus stand at Kolar Town. While he had crossed the northern side road and was standing on open median to cross southern side, at that time auto rickshaw came from Clock Tower side at a high speed in a rash and negligent manner, went to the wrong side of the road and dashed against the petitioner. He fell down and sustained grievous injuries. And it's his case that he had sustained the disability. As per the evidence of the doctor, he had sustained 36% disability to the limb and 12% to the whole body. His case is that he's earning an amount of rupees 15,000 per month. The trial court had taken 4,000 as income and the disability at 8% and granted the compensation as per the table given below. Extract the table. When it comes to the liability, the court has held that the driver of the offending vehicle did not possess a valid and effective driving license at the time of accident. The insurer is not liable to pay the compensation. Accordingly, fix the liability on the owner of the vehicle. Next parallel, and counsel appearing for the appellant claimant submits that even though the driver of the offending vehicle is not having a valid driving license, petitioner being a third party to the policy, the insurance company is still liable to pay the compensation and record the same from the owner of the vehicle. He submits that under the head of pain and suffering, the amount that is granted by the tribunal for the injuries that were sustained by the claimant are not reasonable. It is submitted that towards food, nourishment and attendance charges also, reasonable amount is not granted. When it comes to the income, the accident had taken place in the year 2014. Court had taken the income at 4,000, which is also on the lower side. Next para, counsel appearing for the respondent submits that court has granted reasonable compensation and rightly held that the insurance company is not able to pay the compensation and there are no grounds to interfere with the well-considered order passed by the tribunal. Next para, having heard the counsels on either side, peruse the material on record. When it comes to the liability, as rightly argued by the land counsel for the appellant, though there is no driving license to the offending vehicle, the claimant being a third party, as per the law laid down by the Honorable Apex Court in Swaransingh's case, still the insurance company is liable to pay the compensation and record the same from the owner of the vehicle. Then coming to the compensation, as per the evidence available on record, he had sustained one grievous injury. In that view of the matter, this court is inclined to grant an amount of rupees 40,000 under the head of pain and suffering. Medical expenses, court is granted basing on the evidence on record and no interference is called for. When it comes to food and nourishment, as he was there in the hospital, food, nourishment and conveyance, as he was there, food, nourishment, attendant charges and conveyance, as he was there in the hospital for 4 days, this court is granting an amount of rupees 4,000. Then coming to the loss of income during the later period, as this accident has happened in the year 2014, This court is taking the income at for 8,500. Then for 3 months, it would come to 25,500. Then coming to the future loss of income, the trial court without any basis had taken 8% as disability. When the doctor had opined that there is 36% disability to the limb and 12% to the whole body. Hence, this court is inclined to take 8,500 as income and 12% as disability. Then 8,500 into 12 into 16 into 12 by 100 is 1,95,840. In the light of the law laid down in Mekala versus so and so, to his legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 3,40,350. Accordingly, the appeal of the claimant is partly allowed, enhancing the compensation from 1,66,400 to 3,40,340. The enhanced amount shall carry 6% interest.
Insurance company is liable.
Huh?
Insurance company is liable to pay.
Where is the insurance company appeal?
Insurance company is liable to pay the.
That will be there. These are all, the insurance company shall pay and recover from the owner of the vehicle.
Obliged.
Yes, next.
Cell number 10. AM Venkatesh for appellant.
For the appellant, my lord.
Yes, Antaraj.
Respondent claimants, there are 2 more appeals to be taken along with this, my lord. MFA 4748 after 47519 of 17. Claimant have filed for enhancement. I am challenging on liability.
They are there, 10.2 and 10.3.
Yes, my lord, but notice is not served yet.
Sir,
on me.
Lordship, I undertake to file wakalat for R4 and 10.1 and 2, your Lordship, for R1.
We'll pass the order. You don't have the papers.
No, my lord.
What are you doing without even serving? No notice is ordered. Till now, it is not listed.
Process has been paid, notice already, all notice has been served, my lord. This council submission is only, he has presently the document.
10.2.
No problem, I will give you one copy.
For R1, your Lordship, I'll be.
10.2.
And all parties are appeared in the
748.
connected insurance appeal, 923, 924.
That's what I'm saying in 10.2. Give that 10.2. 2017, still they are waiting for, what is the fate of the clients? We don't know. Gopal T, you take.
Gopal T,
notice.
I
What's your
undertake to
name?
file wakalat. My name is Diksha.
So and so.
So and so.
Takes
Diksha
notice
Amritesh.
on behalf of the first respondent. For the second respondent, in the connected appeal, Mr. A.M. Venkatesh has already filed wakalat. He shall take notice on behalf of the second respondent in these 2 appeals, 10.2 and 10.3. Land counsel appearing for the appellant in 10.2 has served the copies on, he's serving it now. Has served the copies on both the counsels.
Please.
List this matter for, it's coming up, list this matter for admission next
Please.
week.
File wakalat.
Date maybe.
It's in final hearing.
Final year mail.
Now list this matter next week.
Date maybe.
Next week, Tuesday. How many matters are there on Tuesday?
Tuesday, there was lot of matters because previous court has also assigned. Previous court has also assigned.
26.
Please.
And no adjournment on the day.
Please.
Yes.
Cell number 11.
Appearing for the appellant in this matter. What is it? Claimant appeal. Claim petition was dismissed. Claim petition was
On
dismissed.
the ground.
Lord, there is a delay in filing a FIR before the
When
jurisdiction.
was the accident?
Lord, the date of accident is, my lord, on 27/11/2013.
27/11/2013.
Lord, the date
When
of
the-
complaint, my lord, 25/12/2013. There is a 29 days delay in the filing.
What are the injuries sustained by you?
My lord, the injury, my lord, both the injuries are grievous injury. Exhibit P4 is before the trial court, we are marked the document. But the second metatarsal fracture of left foot and third metatarsal fracture of left foot.
Which hospital you were admitted
My lord,
to?
the Hemavati Orthopedic Hospital, my lord, Tumkur. Lord, I have a document, my lord, exhibit P4.
What is exhibit P4?
my lord, exhibit P4 is the wound certificate, my lord, given by the,
No medical, no medical
No.
MLC is extract.
my lord, they are not produced before the trial court, my lord. My one,
You have to produce to say that on that day you have sustained injuries,
my lord,
and the reason would be containing in that.
well, in the FIR, my lord, they have stated after obtaining the recovery from the injury, my lord, I will give as
That might be. Before that, immediately you were
well,
admitted
appellant,
in.
appellant is a senior, 72 years old.
No, it is not about you. They will register if at all you have gone on the day
But
to the
no,
hospital.
Please, my lord, but
And they will record it, and even in the certificate also, it will be written that for what reason you have sustained these injuries.
But my lord, the accident was not disputed by the respondent in this matter. They have stated, my lord, the appellant is traveling in the triple riding. My lord, they have not also proved, but admitted fact, my lord, I have not produced the document regarding, my lord, MLC and discharge summary before the trial court when I have admitted and when I have discharged from the hospital.
You
My
have
lord,
given the complaint, police have filed the charge sheet.
please, my lord. They are the owner of the vehicle. My lord, my reason is this, my lord. The involvement of vehicle is the bus. My lord, the driver of the bus is involved. My lord, the charge sheet was filed. My lord, and even though, my lord, the owner of the bus, nor the, my lord, the insurer, my lord, not challenged the charge sheet. My lord, they have contention, they have not disputed the accident. There is ground, my lord, there is a delay in 29 days. My lord, the appellant is, my lord.
So you have not denied the
My,
accident.
my humble submission is, your lordship may kindly see at page 8 of the judgment, paragraph 11 in length, it has been considered. But
One
after a period of 29 days, he lodges the complaint.
Please.
One minute.
Please.
And my lord, your lordship may kindly appreciate, he has stated that, my lord, he sustained some grievous injuries, fractures, etc. So first time he got admitted to the Himavati hospital on the, after 5 days. Your lordship may kindly appreciate it. If he is in such a serious condition and suffered fractures, etc., immediately, my lord, he will take some treatment in some hospital. And this medical records, what he has produced, doesn't disclose, my lord, that he has taken any preliminary this one examination in some hospital, any treatment. Nothing is there. So accordingly, my lord, your lordship may kindly appreciate, my lord, paragraph 8 of the judgment. Clearly, the trial court discussed all these aspects. And my lord, rightly, my lord, they dismissed the petition of the claimant.
You have
My lord,
admitted
in
to the
this
hospital 5 days after the accident.
5 days
My
after
lord,
the-
in the art, my lord, exhibit P4 once for a moment, my lord, kindly see. My lord, it is clearly mentioned history, my lord, history, my lord, RTA, road traffic accident. My lord,
When a person sustain
my lord, earlier, my lord,
fracture injuries, will he sit in the
but
home
both the,
for
my
5
lord,
days and
foot-
later join?
my lord, foot injuries in the leg, my lord.
My
My lord,
he-
earlier, my lord, he is not attending the direct appear the hospital.
Say that the claimant is a senior citizen. Senior citizen sustaining those kind of grievous injuries will sit at home for 5 days, and after 5th day, he
Lord-
will go to the
My
hospital,
lord, then is,
and after 29 days, he will give a complaint. At least leave away the complaint, we can understand, or maybe he is too injured and he
at the time of accident, my lord, it is not, they have not come to know the, my lord, injuries done.
If
My lord,
those
today is
inju- no, no,
directly, the
even
senior,
if
my lord.
those injuries, can anybody sit at home? That to fracture injuries.
My lord, he was aged about 72 years as on the date of the accident. So such a person can wait for 5 days, my lord.
Let's
As
see
a
the, let's see
criminal, my
the,
lord,
let's
your
come
lordship-
to the discussion part.
Paragraph, my lord, page 8.
Paragraph 9, my
Paragraph
lord,
11. my lord.
9, 10 and 11, my lord.
Read.
My lord, may I read, my lord, 9 or 11, my lord, which one? It is the case of the petition that on 27/11/2013 at about 6:30 p.m. Will the petitioner was proceeding on the Tank Road by Ballapura and Tumkur Billavi Road in the Honda Activa bearing number KA bearing number so on order to attend marriage of his relative at the Chelur. And the point of time, the bus bearing number KA 016B 3416 bearing driver by its drive with high speed and rash and negligence manner come to opposite direction and dash against him and cause the accident. It is further contended that at the result of the said accident sustained grievous injury. The petitioner, in order to substantiate his case and to prove the accident, got examined himself as PW1 and got marked exhibit copy of FIR at exhibit P1, copy of the charge sheet exhibit P2, Mahazar exhibit P3, IMV report exhibit P6, it is strongly contended by the learned counsel appearing for on behalf of the second respondent that the accident in question occurred on 27/11/2013, whereas the FIR was registered on 25/11/2013 after lapse of 29 days. It is further contended that PW1 has not satisfactorily explained the reason for the said delay in filing the FIR. It is further contended that the accident occurred on 27/11/2013, whereas the petitioner got the initial treatment on 2/12/2013 after lapse of 5 days. Therefore, the contention contended that since the petitioner is not an explanation.
I've seen, please come.
Paragraph, my lord, paragraph 11, my lord.
I've seen, I've completely seen that. Agreed with the orders passed in MVC agreed with the dismissal of MVC number 794 of 2015 dated 17th August 2016. The claimant is before this.
My lord, given an opportunity, my lord, before the trial court, my lord, the appellant to file an MLC register extract and other documents regarding the accident is concerned. My lord, because of reason is this, my lord, they have not disputed the accident. My lord, they have stated, my lord, the appellant he was traveling in the pillar.
Even the medical records do not disclose what is the treatment that is given to you.
They are
One
not.
day, 2 fractures, one day you will admit and the next day you will be discharged.
My lord, I am not.
And how can you say that those are grievous injuries? For that reason, you are not able to give the complaint for 29 days. The claim petition was filed seeking compensation of an amount of 3 lakhs for the injuries sustained by the claimant in the accident. It is the case of the claimant that on 27/11/2013 at about 6:30 p.m. The claimant was proceeding on the tank band of Bellapura on Tumkur Bellavi Road in a Honda Activa in order to attend the marriage of his relative at Chelur. And at that point of time, a bus being driven by his driver with a high speed and in a rash and negligent manner came from opposite direction and dashed against him and caused the accident. And he has sustained grievous injury. And immediately he was shifted to Hemavati Hospital and Trauma Center, wherein he took treatment as inpatient for more than 1 month by incurring rupees 1 lakh towards medical and other expenses. The insurance company has taken the contention, has taken the objection that the vehicle is not involved in the accident and the injuries are not sustained by him. It is the case that it's the case of the insurance company that when the accident had taken place on 27/11/2013, the complaint was given on 25/12/2013. And after 5 days from the date of accident, that is on 2/12/2023, the petitioner was admitted in the hospital and immediately he was discharged. And accordingly, they have denied the claim of the claimant.
2013, my lord. 2013.
2013, he has denied the claim of the claimant. The trial court, by order impugned, had dismissed the claim petition. While dismissing the claim petition, the court has observed that when there is a delay of 29 days in giving the complaint, the FIR is silent while the complaint is given after such a long lapse of time. The court also observes that when the accident has happened on 27/11/2013, and when, as according to the claimant, he is 72 years old and sustained two fracture injuries. He was admitted in the hospital after 5 days, and immediately on the next day, he was discharged from the hospital. Even the hospital records also do not disclose what is the treatment that is given to the claimant. And considering all this, the court had felt that the claimant has failed to prove that he had sustained accident injuries in the road accident as alleged to have taken place on 27/11/2013. Next parallel, and counsel appearing for the appellant claimant submits that the court, without considering the case and both the oral and documentary evidence, had dismissed the application. It is submitted that the wound certificate clearly shows that he had sustained injuries in a road traffic accident. That makes it clear that the petitioner had sustained the injuries. He submits that the insurance company had never denied the accident. It is also submitted that as the the MLC extract is not placed before the court, if an opportunity is given, they'll be placing the same on record, and an opportunity may be given to contest the case, and the matter may be remanded to the court. Next panel. When counsel appearing for the insurance company has submitted that the court had considered all the documentary as well as oral evidence and had rightly dismissed the petition, and there are no grounds to interfere with. Next panel. Having heard the counsels on either side, there is a material on record. The accident had taken place on 27/11/2013 and 25/12/2013. The reasons that are stated for giving, the no reasons are the FIR that why the complaint is given belatedly. By way of argument, it is submitted that in view of the grievous injuries sustained by him, the complaint could not be given immediately. Then if he has sustained grievous injuries in the accident and he was not in a position to give the complaint, he should have been admitted in the hospital immediately. Interestingly, in this case, though he had sustained two grievous injuries according to him, he was admitted in the hospital 5 days after, and the hospital authorities have not, even the medical records that are placed do not contain any particulars. What is the treatment that is given to the patient? Further, in the pleadings, it is stated that immediately after the incident, he was taken to the hospital. And that statement itself is falsified by the medical records, which show that he was admitted in the hospital 5 days thereafter. In the considered opinion of this court, all these documents do not, the order of the trial court considered one, and this court finds no evidence of accordingly dismissed. Next. Yes, next.
Apply.
Number 12, Suresh Amlatur.
For respondent number 2, my.
For the appellant, my lord.
Yes.
I am for the appellant. I am ready, my lord. I am ready. In this case, the accident has taken place on 25/4.
This is for enhancement or on liability?
It is enhancement only, my lord. There is
What
no
is the
liability.
compensation that you have claimed?
The claim amount is
10 lakhs, madam.
10 lakhs.
What was the amount granted?
3
3
lakh.
lakh.
Hmm?
Yes.
3,24,000 is granted.
24,000. Is it a case of any
Injury.
disability?
Injury,
Any
ma'am.
disability?
Disability, my lord. My lord.
Yes, my lord.
A doctor has assessed 43%, my lord.
43% disability to the limb.
Particularly.
Right lower limb.
And how much the court had taken?
14%, 1/3 has been considered, my lord.
What is which year is the accident?
The year of accident is 2017, my lord. The notion,
Taken as
it has taken 7,500, my lord. As per Lok Adalat, it's 11,000, my lord.
2000.
No. 11,000.
That's what he's
11,000.
also saying.
11,000.
Court had taken
11,000 has to be taken.
7,500 has been.
7,500. According to him, what is his income?
20,000. He was working as a mason. No documents has been produced as per the findings.
Please come to the chart.
Chat, my lord, page, in page 16 of the judgment, my lord. Para 36, my lord.
Page 10, para 20, my lord. Quantum.
How many injuries?
Both the
Injuries.
bone fracture, my lord. Right lower limb.
One fracture or two fractures?
2
A
fractures.
fracture of both bones of right leg. Both.
40,000 is a reasonable amount. Loss of income during laid up period.
2 months has been granted.
Or 3 months, I think.
3 months, sorry, my lord. 3 months.
$33,000. Medical expenses, no dispute.
No dispute, my lord.
Then loss of future income,
Yes, my lord. Here
11,000 to 12.
is a mason, my lord.
What is the multiplier?
It was 34 years, 16, my lord.
16 into 14. It comes to 2,95,680. Loss of amenities. Another 20,000 will grant.
Yes.
At how many days he was in hospital?
14 days he was in prison.
Then reasonable only that nourishment and the conveyance. 20,000. Future medication.
20,000.
Removal of
What basis it
implants,
is
my lord.
given?
He has to go for removal of implants.
20,000. Legal expenses, 10,000. Comes to 4,58,680. Please come. The agreed with the claimant is before this court seeking enhancement of the compensation. Agreed with the orders passed in MVC number 2753 of 2017. Dated 13th April 2018. The claim petition is filed seeking compensation of an amount of rupees 10 lakhs for the injury sustained by the claimant in the accident. It is a case of the claimant that because of the rash and negligent driving of the driver of the offending vehicle, he had sustained fracture injury to both bones of the right leg. And as per the evidence of the doctor, he had sustained 43% disability to the limb and 14% disability to the whole body. The tribunal had considered, according to the claimant, is
Doctor
only
has one submission, my lord. Doctor has stated whole body disability is 21.65%.
how much?
21.65.
We have to take it 1/3. The
Yes.
doctor cannot say. The doctor has stated that the whole body disability is
1%, 21.65.
21%. The tribunal had taken, according to the claimant, he is earning 20,000 per month. The tribunal had taken the income at 7,500, disability at 14%, and granted the income as per the table given below. Take this table. Learned counsel appearing for the claimant submits that the accident had taken place in the year 2017. Court ought to have taken 11,000, but taken only 7,500. It is submitted that when it comes to the disability, the court had not taken the disability as stated by the doctor. The claimant is a mason and towards is not a reasonable amount. He submits that on all counts, the compensation needs to be enhanced. Land counsel appearing for the respondent insurance company submits that court had rightly taken 14% as disability as 1/3 of 43%. He submits that on all counts, the compensation that is awarded is a just and reasonable one. Next para. Having heard the counsels on either side, there is the material non-record. The claimant had sustained fracture of two bones of the right leg. Under the head of pain and suffering, court had granted 40,000, and this court finds no reason to interfere with the same. Coming to the income, this accident had taken place in the year 2017. Considering the table, as per the table prepared by the Legal Services Authority, this court is inclined to take the income at 11,000, and for 3 months it comes to 33,000. Medical expenses, there is no dispute on that. Then coming to the loss of amenities, considering that he is a mason, this court is awarding 30,000. Towards attendant, nourishment and conveyance, future medication, court had rightly granted 20,000 and no interference is called for. Then coming to the loss of future earning, this court is taking the income at 11,000 into 12. The multiplier 16 into 14 by 100 is 2,95,680. Next para, in the light of the law laid down by the apex court, in make a loss so and so towards legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 4,58,680. Accordingly, the appeal is partly allowed, enhancing the compensation from 3,24,000 to so and so. Enhanced amount shall carry 6% interest. Yes, next.
Number 13.
Why the insurance counsels are not at all seen in the court?
No, my lord, we are
From one, nobody was there. So many matters were called.
some little bit confusion or something.
Yes.
But
Sita Ramara was also not there, posted for dismissal.
Miss
Earlier matter.
Keshavamurthy B for appellant, cell number 13.
only for quantum land,
Only on quantum, very easy. We'll have it tomorrow, dismissal.
please.
No representation for the appellant for
Or
dismissal.
I will assist the court.
Hmm?
Or I will assist the court if the court
Because
wants.
they should be there
Please.
when the order is passed.
Please.
If they are not coming, then tomorrow we'll do that. Tomorrow for dismissal, no representation for the appellant. It's 14.
14. Patel D Karegowda.
This is also for dismissal tomorrow. No representation. Yes. No, this matter is the next list. Call that.
Matter pertains to Dharwad. Cell number 1, Gode Nagraj for petitioner. P.
My lord,
Who appears for the petitioner?
my lord, it is a disposal of matter.
That's what I'm saying.
Golden
Where
Nagaraja was appearing. My lord, I tried to serve the copy. He said since it dispose of matter, my lord, he wanted a notice to go to the party.
Then shall we answer order notice?
My lord, the reason is I moved the matter is, my lord, the maintenance has enhanced from 15,000 to 75,000 rupees. But I had no notice in the, my lord, the High Court.
Give that order. There must be a reason recorded in the order why it is. There is the order.
My lord, the two things, my lord, have not been brought to the notice of this honorable court. One is, my lord.
No, before going to the other things.
Yes.
We'll see why without a notice to you, order is passed. Where is the order?
My lord, my client's, my lord, my counterpart instruction is acknowledgement is there in the, this one. But there is no signature in the acknowledgement.
Where is it? How can it be? Where is the order?
I have not seen the records, my lord.
Order passed by me. They're seeking review of that. Though notice is served on the respondent, no wakalat is filed on behalf of the
Yes.
respondent. Look at the notice. What has happened to the notice? There is a signature on the acknowledgement. No, look at the acknowledgement. It is there. Sure. So the signature will be. What is this? It's only the address that is written. Registry shall place a note. with regard to the service of notice on the respondent. List this matter on Monday.
Reason I moved here is, my lord, on 20, they have filed an execution petition.
Tomorrow? Tomorrow?
Yes. Because, my lord, the last time when
No,
they filed
unless and until court affirms that the notice is not served on you.
notice, there is
From
no.
the record, because court, as per the cause list and as per the endorsement, as per the report of the place by the registry, court has recorded that it is served. So on
But-
what basis they have said so?
But acknowledgements, my.
That's what we'll find out from them. Ask the. Huh? It is a new one, now it is filed. The registry shall place a report before the court with regard to service of notice on the respondent. On basing on what the endorsement shows that the notice to respondent is served. List this matter tomorrow.
Monday, my lord.
Monday,
Yes.
court has no objection. You are saying it is urgent, that's why I'm saying.
No, 26th is the execution.
Monday. Yes, any other matters where both the parties are ready?
Madam, may I permit to see the records, ma'am?
Please see the record. Give it to him.
Number one, serial number two was passed over by this court in the morning session.
Serial number?
Serial number two, Patel D. Karigoda, for non-filing of translated copies, sir. The court said it has to be held today. I have also spoke to other person, my friend, who said that I will also provide the documents. So now he has not come, maybe taken up any day.
Let's not adjourn the matters like this. I'll call it in the afternoon. If it is not there,
Please, my lord.
I'll dismiss it.
Please.
That's not our problem there. Somebody has to tell that. Yes. Pass over.
Please.
One submission.
Yes.
I'm sorry, I'm sorry, I missed third matter, I'll appear tomorrow,
Tomorrow, it's posted to tomorrow.
I'll
Tomorrow for
appear tomorrow,
dismissal. Yes.
Please,
Serial number 6, my lord, thirdly.
Passed list number 1, serial number 2. Patel D. Karagowda for appellant. A.M.
For
Venkatesh.
appellant. In this case, I was directed to furnish the translation copies, my lord,
Of what?
of FIR and the other trial
Not
court record.
required, argue.
Claim petition came to be dismissed, my lord. It's a case of injury.
Why it is dismissed?
Dismissed on the ground, my lord. Complaint was lodged after lapse of 5 days of the act.
5 days.
5 days there is delay in lodging. The contention of the
Come to,
insurance.
please come to the order. What are the exhibits?
Exhibit, my lord, in judgment copy, para number,
FIR, complaint, Mahajar,
please,
wound certificate,
please, my lord. All these documents are exhibited.
discharge card, medical bills. Come to the finding of the court.
Please, ma'am. Page number 8,
What is it? 8.
issue number, commencing 6, page number 6, commencing. In the petition amendments, nowhere it is mentioned as to who was riding the motorcycle. This fact was suppressed in petition. Petitioner was examined as PW number 1. In the affidavit evidence, he has not disclosed who was riding the said motorcycle. It is not accidental omission. It appears deliberately suppressed the true facts. PW number 1 in his evidence has stated that he, along with Shashidhara, were going in a motorcycle belonging to Shashidhara towards Yelagiri village. They were going NH4 at 9:30 p.m. They reached at the backside of a CB temple, 6CB village. At the time, rider of the motorcycle bearing number so-and-so came from the opposite direction on the same side of the road, dashed against the petitioner. Due to impact, he fell down and sustained grievous injuries. His friend Shashidhara contacted the contractor by name Jagdishaya, whom PW number 1 was working. Said Jagdishaya admitted him to the hospital. He took treatment 2 days in the district hospital government Tumkuru. Thereafter, he was shifted to Victoria Hospital, Bengaluru. He was cross-examined by PW number 1 to respond number 2. The cross-examination he says that he was not holding a driving license to drive two-wheeler. Further, he stated the place of accident is highway and there was 2 sides of road and both are one way. It was not possible for the vehicle to come from opposite direction on the same road since it was one way. He says that his friend was riding motorcycle at the time of accident. He lost consciousness immediately after the accident. 8 days after the accident, it was intimated to him that the accident was taken place by the motorcycle bearing number so-and-so. His statement was recorded by police 3 days after the accident in the Victoria Hospital, Bengaluru. He does not know whether the vehicle in which he was traveling was insured or not. It was suggested to him that he was riding the motorcycle without holding a valid license and fell down from the said vehicle. Since it was not insured and he was not holding license, he falsely implicated the vehicle belonging to respondent number 1 to claim compensation. PW number denied the said suggestion. Looking into the facts of the case and contents of the charge sheet and enclosures, said suggestions appears to be probable. PW number 1 admitted that he was not holding a driving license. It is not
MLC extract.
MLC extract.
It is marked as
An exhibit here.
There is no MLC extract.
No MLC extract. No.
It is such a fatal injuries you have sustained. You were unconscious. Then the police might have the MLC entry must
They
have
have
been
to
there.
register MLC. No, it is
No,
not.
you don't even say. Now you say that somebody else is driving, you are a pillion rider.
Yes,
And that person, as per the medical police records, you were riding the vehicle and the other person is the pillion rider.
yes,
Those are all there also, there are discrepancies. You don't place the MLC extract before the court.
he was unconscious for a period of 8
No.
You are unconscious. For that MLC extract, somebody might have taken you to the hospital.
for the-
Hospital people will record the statement of the person.
Yes,
PW 1 or 2 has taken you to the hospital. They would record their statement that in a RTA you have sustained so and so. Something would be there.
Please, my lord, for the default of the hospital authority and police, my lord, claimant should not be suffered.
Court was right. Please come.
But if I'm permitted, my lord, I will submit the documents with translation.
Not
Make out
required.
part.
I do not want to look at any of the documents not required. In all the cases, translated copies. Why translated copies are required? For each and every case, we don't even have to look into it. Even if the court do not understand Kannada, your people are there to read and tell the court. And in a 2013 appeal, now translated copies. The present petition is filed. The present appeal is filed by the claimant, agreed with the dismissal of MVC number 736 of 2011 dated 31st December 2012. The claimant filed the petition under section 166 of the MV Act. The facts of the case are that on 23/11, the claimant along with his friend Shashidhara were going in a motorcycle. He reached near CB Temple, Chikka, what is that? Chikka CB
village.
LV Hobli. At that time, motorbike ridden by its rider in a high speed, in a rash and negligent manner, came from the opposite direction and dashed against the motorbike in which claimant was traveling. Due to impact, he fell down and sustained injuries. He was shifted to the district government hospital, Tumku, for treatment. He was admitted as inpatient for 2 days in the hospital. He was shifted to Victoria Hospital, Bangalore, wherein he was admitted as inpatient from 23/3/2011 to 11/4/2011. He underwent operations. After discharge from the hospital, he took follow-up treatment, and he had spent more than 1,50,000 towards the medical and incidental expenses. The insurance company has opposed this petition, stating that the vehicle is not involved in the accident and no such accident had taken place. And the complaint is given after 5 days. And why it is given after 5 days, there is no explanation forthcoming. The tribunal, by order impugned, had dismissed the claim petition. While dismissing the claim petition, the court has observed that PW1 suppressed in petition and in his affidavit evidence as to who was riding the motorcycle. In the cross-examination, he says that Shashidhara was riding the motorcycle. According to his admission, police recorded his statement in Victoria Hospital. Such statement is produced at Exhibit P5. It shows that he was riding the motorcycle and Shashidhara was pillion rider. Statement of Shashidhara is also produced, though it was not marked. It shows that petitioner was riding the motorcycle and Shashidhara was a pillion rider. And the claimant, whenever I say petitioner, it is claimant. Claimant knew that he does not have the driving license. The court came to the conclusion that the police have not even inquired whether PW1 is having a driving license or not in the charge sheet. And without holding a valid driving license, he was riding the motorcycle. Considering the delay of 5 days, particularly in the facts and circumstances of the case, the court came to the conclusion that the claimant had failed to prove that the accident has happened because of the rash and negligent driving of the driver of the offending vehicle, and accordingly dismissed the petition. And counsel appearing for the petitioner, appearing for the appellant, submits that delay in filing the FIR cannot be a delay in giving the complaint is not, it cannot be the reason for dismissing the application filed by the claimant. It is submitted that the Honorable Apex Court and this court has considered the delay in several cases and still entertained the petition. She submits that as he has sustained the grievous injuries, there was a delay in giving the complaint and all these aspects were not considered by the tribunal. Then counsel appearing for the insurance company submits that
The charge sheet is filed against the charge sheet was
he
not-
submitted that the charge sheet is filed against the driver of the offending vehicle. That itself shows that there is the accident has happened because of the negligence on the part of the rider of the offending vehicle. And these aspects were not considered. Next, learn counsel appearing for the insurance company submits that the court had considered the documentary as well as the oral evidence available on record and rightly come to a conclusion and dismiss the claim petition. It is submitted that there are several inconsistency in the evidence of the parties and no interference is called for with a well-considered order passed by the tribunal. Next, para, having heard the counsels on either side, there is a material on record. In this case, the complaint is given after 5 days from the date of accident. Mere delay in filing the complaint cannot be a ground for the court to dismiss the application seeking compensation, but that depends upon facts and circumstances of this case. According to the claimant, he sustained grievous injuries. He was unconscious. He was taken to the government hospital. If he is taken to the government hospital, in the MLC register will contain all these aspects, and the court, they will record the same. No such extract of the MLC record, the register is placed before the court and placed before the court. In that case, the medical records would be the first evidence to place before the court. In the absence of that, the lapses on the part of the claimant in giving the complaint. In addition to that, the manner in which the claimant has narrated the incident without even disclosing who is riding the bike. And thereafter, in the evidence, stating that he is the pillion rider and Shashidhara is riding the bike, when as per the police records, Shashidhara is a pillion rider and this claimant is riding the vehicle. And admittedly, this claimant is not having a driving license to drive the vehicle. And the accident had happened at the night time. Considering all these aspects, the tribunal had rightly dismissed the petition and this court finds no reasons to interfere. Next.
List number 2, serial number 2.
List number 2.
My lord, I appear for petitioner.
Yes, 1 minute. List number 2, serial number 2.
Okay, the respondent had filed a MC petition number 10/2024 at Devanahalli.
Who is the petitioner?
Preeti,
Petitioner is a wife or the husband?
husband. A petitioner is a wife, respondent is a husband.
You're
So-
seeking transfer from where to where?
Devanahalli to Madur.
Devanahalli to Madur.
Madur.
What is the distance?
Maybe hardly 3 or 4 hours.
It can't be maybe hardly.
I am not sure about the distance.
You have
my
to
lord.
be sure when you're filing a petition and you have to tell the court what is the distance, why do you want it?
It's not more than 4 to 5 hours, my lord. I'm damn sure. But the petitioner finds difficult to travel from Madur to Devanahalli as there is already a case registered in Madur for maintenance. So she finds it difficult to travel as she is having health issues as well. And she is dependent on her parents, who is agriculturist, and finds hard to.
Please come.
One.
The present petition is filed seeking transfer of MC number. What's the distance? 125 kilometers. The present petition is filed taking transfer of MC number 10 of 2024. Pending on the file of the third additional senior civil judge and JMFC court at Devanahalli. 2. The principal civil judge and JMFC Madur. The facts of the case are: the marriage was solemnized on 10/6/2022. It is a case of the wife that the husband deserted her on 17/9/2023. Thereafter, the wife had initiated the criminal proceedings and the same is registered as crime number 2 of 2024. Thereafter, the husband had filed the suit for divorce. It is a MC, filed a MC
Yes, my lord.
10 of 2024, seeking divorce. Wife at the family court, Devanhalli. The wife had filed the criminal miscellaneous, that is criminal miscellaneous number 111 of 2024 on 4/6/2024, seeking maintenance. In that, the husband has filed his wakalat and contesting the matter. An interim maintenance is also granted. It is submitted that the wife is residing in Madur along with the parents, and the distance between Devanahalli and Madur is about 120 kilometers, and it's difficult for her to travel on each date of hearing from Madur to Devanahalli. It is submitted that the wife is depending upon her parents and considering the inconvenience that's being caused to her, the case may be transferred from the pending case for pending MC 10 of 24 may be transferred from Devanahalli to Madhu. Next paragraph. Though notice is served on the respondents, no wakalat is filed on what is this? This is served or held sufficient?
Refused.
Huh?
Served and refused.
Served. ST it appears. The notice is served on the respondents. No wakalat is filed on his behalf. Having heard the land counts for the petitioner, there is a material on record. The wife is residing along with her parents in Madur, and it's a case that she has no source of income and dependent on the parents. The distance between both the places is 120 kilometers. And considering the inconvenience that's being caused to the wife, this court is passing the following order. This court is inclined to allow the petition accordingly the following. The MC number 10 of 2024, pending on the file of the third edition senior civil judge and JMFC at Devanahalli, is withdrawn and transferred to the principal civil judge and JMFC Madhu. The next point number 2, the wife shall cooperate with the trial. Yes, next, allow.
Serial number 9, list 2, serial number 9. Arjun Rao.
Please, my lords. I'm extremely, my lords, to begin with, I'm extremely obliged, my lords, for agreeing to take up this matter, my lord. My lord, I1, which we have preferred, which the respondent number 1 vessel, my lord.
We'll hear them. You can also submit, she has filed the petition.
Yes, my lord, it's my application to vacate and to return of security furnished by me. Whichever way, my lord, the court wishes, my lords,
We'll understand this way.
Yes.
Yes, what's your case?
Please, my lord.
Let's see, where is your prayer?
Please, my lord.
Page 37.
30?
7 of the petition.
Prayer is for arrest of the vessel, my lord.
So, when you are filing a petition, you are not seeing, no, this is not an interim prayer.
This is also an interim prayer, my lord.
No, interim and main prayer or can't be one and the same.
Please, my lords. Please, my lords. This is the manner in which this petition comes to be filed. It is seeking security of my claim. Finally, my claims are being adjudicated in arbitration because there is an arbitration clause. However, this is only for security of my claim.
This is directly contrary, my lords, to 2 judgments. I'll place that whenever my turn.
Yes, yes. So now please come to the facts of the case.
Yes. My lord, I engaged with the respondent number 3 and entered into a time charter whereby the vessel, which is the CS Flourish, this vessel was to be given to me
for a particular period of time for me to transfer goods and transport goods from one place to another. Now, what happens is there was a particular date and time fixed for me to get the vessel from them. They do not give it to me at that time and date. There are several communications that I have produced where I say, when am I getting this? Oh, you will be getting it at so and so time, at so and so date. The communications go on. Finally, what happens is I do not get the vessel. Therefore, I terminate the time charter. Then I send a legal notice. Then I send 2 legal notices. I do not get any response. Therefore,
Let's see
then I
your,
find.
let's
get
see
the
your legal
information.
notice,
Please,
the
ma'am.
last one.
Please, ma'am. Lord, my legal notice is
Page 440.
please.
So as I called with section people, regard to the whole cases, I've asked them to pick up the cases. The 2014-15 insurance company, let them act tomorrow. Whatever that is left, we can.
Annexure S.
No, I have, yes, they come to chamber, again tell them, at least 30 to 40, let them add tomorrow's list. We'll see. Yes,
At
which page
Annexure
number?
S, my lord. That's my legal notice, letter of claim.
Page number?
440.
Page number?
440.
I don't think so. The page number ends at 250 or 260.
My lord, there'll be a volume 2.
Yes.
Yes, I apologize. 450, volume 2.
Wait. Look at it, no such page mention of 400.
Here we go.
Even in the other volume also, it's all in 200s.
Here we go. They all are yes.
What is the date to the volume?
Here we go.
Dated. When did you file it?
I filed it along with the petition. And the pointed this.
Numbers are not 441 like that, it's not there. This is another volume. There is another volume, that's what she's saying. Look at it. It starts from volume number 2, annexures are 21 like this, numbers are there. Give it to her.
Okay.
Petition only there. Only the one.
Volume 2 ಇದೆ.
Only this papers are up by the branch.
It's not there.
I've given, no, it's my spare copy. Of
You
it.
have?
You have filed volume 2.
Along with the CP. At the same time. And
No.
in fact, this, we had pointed this out to the honorable judge who had seen the documents before passing the order.
It's written here. So it's volume 2. Here it is. The volume also you have not mentioned in the main file.
I mentioned it's there in the index, volume 2 and the bardi. I backed it, my notes.
No. Sorry, you got. If the court have this bundle, you have something to refer?
I have something to refer.
Oh, yes,
Not
let's see. Yes,
My notes. 440 is my legal notice to them.
440.
Page number 440 is my legal notice to them. (440) to the owners of CS Flourish and to disponent owners of CS Flourish. Letter of claim. Under the charter party, owners agreed to charterers agreed to hire the vessel for a period of 6 months, 15 days. Laycan for vessel delivery was established as so-and-so being initial cancelling day. Further, owners were obliged to tender to charterers not less than 10-7-5 days approximate notice of vessel's expected date and probable date of delivery. Owners violated the above prescribed procedure. The only notices were as follows, and it mentions what we received from the respondent number 3. Next page. So the charterers have received this one approximate delivery notice and 3 delivery definite notices. As prudent charterers, our clients have made necessary arrangements for cargo and surveys being ready for that date, bearing in mind the definite notice. However, on 21/2/2023, no delivery notice was tendered. Neither it was on 22/2/2023 and on 23/2/2023. On 24/2/2023, owners advised about some necessary additional repairs. Charterers reluctantly granted Laycan extension. Same was not done since all relevant preparations were already made. Then, Your Honor, it just describes the chronology of then what happens. On 23/2023, it turned out that the owners were purposely manipulating charterers with allegedly completely false information on planned inspections. Then on the next page, charterers basing on owners' approximate and definite delivery notices reasonably assumed vessels' arrival to their custody on or within 21 or 22nd of February 2023. However, due to the vessel being unseaworthy as claimed by PSC, the vessel did not arrive to the charterers at all. Neither substitute vessel was ever suggested or delivered by owners. In the meantime, charterers have arranged necessary preparations for their services. Following documentary proven losses were suffered by the charterers due to the breaches. Expenses were lashing and dunnage arranged in Antwerp to be put on CS Flourish and its storage. So and so your.
When was the order grant? Date of order?
These matters.
24th of July 2024.
24th?
July 2025.
Yes.
So all of this was considered and an order is passed to arrest the vessel. Now thereafter, Your Honor, what happens is the respondent who claims to be the original owner of the vessel, my claims, and the respondent number 3 is the charterer of the vessel. They come and they say, we want to have the ship released, please accept this security for so that we can ensure the release of the vessel and the vessel can go on. An order comes to be passed on that on 5/8/2024. In that, the court accepts their
When is that?
security.
5/8/2024?
5th August 2024. So they come and secure my claim and have the vessel released.
In view of the aforesaid facts, just and appropriate to allow item number 4 and direct release of the subject vessel with which was arrested by the order dated 24/7/4 immediately upon the receipt of a copy of this order.
Yes.
And then thereafter,
They furnish a security. They furnish a security, which is why the vessel is released. They make out a DD and they furnish the security to the tune of 15 crores, securing my claim. And the vessel is released. In this order, it is also mentioned, my lords, I would like to point out para 9. It is also made clear that the arrest of the subject vessel, the deposit made and the release of the vessel shall be by way of interim arrangement and without prejudice to the rights and contentions of the parties, and all rival contentions between the parties on all aspects of the matter are kept open to be decided by
So
this
now
court at the time of final disposal of the matter.
now there is that the vessel is released.
When is
Vessel is
vessel
released, my 15 crores are, so what happens, my lords, in Admiralty jurisdiction, as your lordships are aware, the vessel is the security.
Yes.
But my lord, since arrest of a vessel has drastic consequences, not just on the owners, but my lords, on every party, there is cargo on board, so cargo interest, charterers. So to obviate that, what happens is the vessel is substituted with money as a stopgap arrangement to mitigate losses. So this vessel was substituted with 15 crores of rupees, which are, my lords, stuck in this court because, my lord, the arrest was ex parte without notice to us. So fuller facts were not present. So therefore, my lords, an application is generally preferred, as is preferred, my lords, in all the 8 high courts, which has Admiralty jurisdiction, to vacate the order of arrest. Because the arrest, the vessel is substituted with money. So you vacate the order of arrest and return the security. So if it's money, then return the money to the owners. And if it's the vessel, then the arrest is, my lords, ordered to be released. The reason why this application is to, my lords, 15 crores for a liability of a different party. The owner was compelled to come and deposit 15 crores. And I will demonstrate on reading of the act. I'll come to case law later on a plain reading of the act. It is not permissible, and it is their case. And my friend is very fair to say liabilities of defendant number, respondent number 3. The respondent number 3 is not the owner of the vessel. The vessel owned by the owner is arrested for someone else's liability. And I will demonstrate in law.
Agreement is with whom?
With defendant number 3. I am not a party to that agreement.
If I may just say, the Admiralty Act also provides me a way, if my lord see section 5.
No.
It
Please
says
come to
that
the-
my
please come to
agreement.
the cause.
No, my agreement is with respondent number 3. There is no difficulty about that.
Let's just see.
Please,
Give that, give the file. Let's just see, let's look at the cause title.
Yes. Page 9.
Continental Dry Bulk Limited.
That's correct.
Respondent number 3.
You represent them.
No, my lords. Respondent number 3 is a person who was only a charter. He is not the owner of the vessel. For his liability, my vessel is arrested. And I will demonstrate, my lords, if the owner is not liable, his vessel can never be arrested. Not just in.
Then your respondent number?
1. The
My lord,
vessel.
he is appearing as the registered owner of the vessel. My claim is against respondent number 3. There is no difficulty about that. However, I am permitted to, by the Admiralty Act, to seek arrest of a vessel if I have a claim against the charterer. My contention is that the vessel was under the charterer even at the time of the arrest. Therefore, there is nothing wrong in what I have done in my arrest. That is my contention. They come and say, actually, you don't have a claim against me, so how could you arrest the vessel? If I can take my lords to the Admiralty Act, I can show my lords what my claim arises from.
We'll do one thing, we'll just hear him on this, then you can respond to that.
Please, ma'am.
Yes.
I'll very briefly indicate. My lords, your lordship has seen the prayers, your lordships have seen the cause title. I have 3 submissions. Let me give a broad bird's eye view and straight take my lords through the pleadings. It will demonstrate, my lords, the present petition cannot sustain. My ground, there are 3 grounds, 3 broad grounds on which I seek vacating the order of arrest. 1, there is no liability of the owner, admittedly. The liability is of a different party who's a charterer of the vessel. On this ground, arrest has to be vacated. Second, false statements have been made which are born from the record, and I don't even have to trouble the court with anything. From the own showing of the petition itself, I will show that there are false statements made basis which arrest was obtained. Third, there is gross suppression of fact. And fourth, which the court rightly, my lords, pointed out, that can a suit or can a petition only be filed for an interim relief? I will show direct to Bombay High Court judgments, which says that this is not permissible. Now, before I come to that, the basis of arrest. Please see, my lords, may I invite my lords' attention to the pleadings first. 7 paragraphs, and I will show, my lords, how the case is not maintainable. My lords, if I may invite my lords' attention first to page 61. This is their document, the document that they have produced. 61 of the petition. This is an equasis report which gives, my lords, who is the owner of the vessel at the time of arrest. So please see at page 61, your lordships will find the name of the vessel, CS Flourish, which is respondent number 1. If I may invite my lord's attention, and the last update was of 19th of July, 2024, no difficulty. Page 62, the very next page, my lords. Please see who is the registered owner of the vessel. CS Flourish Limited. So, my lords, the owner of, I am the CS Flourish, who is the registered owner of the vessel. Now, keeping this factor in mind, please see what is the case in the plaint. If I may invite my lord's attention first to para 4. And I'll demonstrate how, my lords, the first paragraph itself starts with a false statement. Respondent number 1, hereinafter the respondent vessel is a seagoing vessel flying a flag of Panama, is identified its IMO number as mentioned in the cause title. Please note the next line now. The registered owner of respondent vessel is Guangdao Sea Star Ship Management, belied by their own document, which shows it is CS Flourish Limited. First false statement. Incorporated under the laws of China, having address so and so. Come to my lords, if I may invite my lords' attention to para 6. Respondent number 3 is the Continental Dry Bulk Limited, which is the disponent owner of the ship, who has by way of a charter party agreement obtains right to use and possession of respondent vessel from the owner. I must just ask the court to mark this word disponent owner, and I will show it marine dictionary. Disponent owner means time charter of the vessel. Then, my lords, if I may invite my lords' attention to the cause of action. What gives them a cause of action for filing this action? Page 12, para 8. The petitioner and respondent number 3. So now this makes it clear between whom is the agreement between. Petitioner and respondent number 3 entered into a time charter. Please note time charter dated 6 January 2023, whereby respondent number 3 agreed to give for hire respondent number 1 to the petitioner for a period of 6 months, 15 days. Next, my lords, para 9. Petitioner has a maritime claim under section 4 and 5(2) of the Admiralty Act for loss or damage. Now, please note these next words are of importance due to failure of respondent number 3. So, agreement with respondent number 3, breach by respondent number 3, damage is caused on account of respondent number 3 in para 9. And for this, please see, my lords, page 13, the last 4 lines of that paragraph. The petitioner is entitled to receive the said amount as the petitioner has suffered loss and damages on account of breach of time charter by respondent number 3. Now come to my lords, para 10. Petitioner's claim arises under a time charter, an agreement related to use and hire of the vessel. As your lordships have seen earlier, this time charter is between petitioner and respondent number 3, not with the registered owner. May I now invite my lords' attention to the second false statement in para 13. And please see, my lords, how this is a false statement in teeth of, my lords, the documents that they have produced. Registered owner of the defendant of the vessel chartered the vessel to respondent number 3. The charter is alive and subsisting till date, and the owner is respondent number 3. Contrary to their own document, respondent number 3 is not the owner. The owner is, as I have shown, my lords, from their own document, CS Flourish Limited. which is correct. I will show, my lords, the certificate from the registry where the vessel is registered shows that it is CS Flourish Limited. So, my lords, second false statement, they now portray that respondent number 3 is the owner because my lords, it is very clear. They have an agreement with respondent number 3. The breach is committed by respondent number 3. Their grievance is against respondent number 3. They know they can't arrest a vessel owned by someone else because you are not a party to the contract.
What is the relation between respondent number 3 and 1?
Respondent number 3 is the charterer of respondent number 1. So, my lord, what happens? Let me give my lords an example. If I have to explain this in property law, not really in that, but just for ease of convenience, owner of a flat or of a property is A. He gives the time charter, means he's given it on leave and license agreement to Mr. B only for the license period. As your lordship knows, leave and license does not create an interest in the property. So likewise, time charter does not create an interest in the property. He may now, if respondent number 3 in this case, which is like the licensee, enters into an agreement to which the owner is not a party, agreeing to sublet that property or give that property on license for a further period with someone, for the breach of that agreement, the owner's property cannot be attached. That is the long and short of the case. Lords, I will demonstrate. In this case, they make a false statement that no, sorry, respondent number 3 is the owner of the vessel. At one place, they say it's Kwangdo, some party which is not the owner. Second place, they say respondent number 3, which their own document shows is not the owner, but they say it is the owner. Now, let's please see thereafter, para 14. Respondent number 3 and petitioner entered into time charter for the petitioner to use and hire the vessel for a period of 6 months. So someone else says, I will give you the vessel, my vessel, and on that basis, which was given to him to exploit, commercially exploit, he agrees with the party that I will give you this vessel, fails to give the vessel.
Oh, that agreement between you and the third respondent.
Not annexed to the petition.
No.
How will I have that agreement?
The agreement, 1 minute, the agreement between
my lord,
the third respondent and you, will it give him a right to further give it on charter?
My lords, 2 aspects. If in a time charter party, if there is a specific agreement, he can for that period give only for that period. But I am going to show that a time charter, since he has no interest in it, my lord, this law is now settled in fact by Supreme Court, and my lords, followed by latest by the Bombay High Court, which says that a charterer, for a breach of a charterer, the owner can never be made liable. Directly on point. I will come to that. First, let me show my lords, convince my lords on the pleadings, and within 5 minutes, my lords, I will convince my lords on the law.
Yes.
Please see now para 14. On 6/1/23, respondent number 3 and petitioner enter into time charter for the petitioner to use and hire the vessel for a period of 6 months, 15 days. So again, contract between petitioner and respondent number 3. Para 15, just see the 3 lines from the middle, just to save time. As per the charter party, respondent number 3 was to give the petitioner not less than 10, 7 or 5 days notice for respondent vessel. So again, my lord, contractual obligation between...
You're reading para 15?
Yes, my lord. I was reading it from the middle. As per the terms of the charter, the respondent number 3 was to give the petitioner not less than either 10, 7 or 5 days approximate notice of respondent vessel's expected date and portable port for delivery, followed by 3 to 1 days of definitive notice of date and the port of delivery. So this is again a contractual obligation between 3 and petitioner. Now, if I may invite my lord's attention straight to para 20. On the same day, 22nd to 23, petitioner submits a letter of protest where they demanded all cost and expenses suffered by the petitioner due to respondent number 3's failure. Breach is of respondent number 3. Then, my lords, if I may invite my lord's attention to the straight, I have shown my lords. I'm just going to, my lords, indicate. I will not waste time reading each and everything. Please see, my lords, para 25 at page 20. Now I'm going to show my lord, each correspondence that my friend refers is not with me as the registered owner, but with respondent number 3. 7/3/2023, respondent number 3 kept sending emails. Next para 26, on 9/3/23, respondent number 3 sent another request. 27, again, my lords, para 27, on 12/3/23, respondent number 3 was saying. On 28, respondent number 3 asked for further extension. Para 29, respondent number 3 asked for further extension.
All the correspondences
is with respondent number 3. Now, please come to para 32. This is very important. On 1/4/23, respondent number 3 asked for further extension of cancellation date up to so-and-so due to some additional repairing work. The petitioner did not accept further extension and they exercised the right to terminate the charter party reserved the right to claim all damages, cost and expenses suffered by the petitioner. I'm going to read this a little slowly, my lords. Suffered by the petitioner due to breach of contract by the respondents. Now they use this in plural. Deliberately, my lords, trying to show, otherwise it is the contract is with respondent number 3. The petitioner clearly stated that they will exercise all available remedies to secure their losses, including but not limited arrest of respondent vessel, or next line is important, or any other vessel belonging to respondent number 3. So they know for the breach of that party, they can arrest their vessel, not my vessel. Now, further, a copy of the trail mail dated 30th, 31st, 1st April is produced. Then they say is produced. Para 33, respondents have deliberately manipulated the petitioners regarding delivery of the vessel and have led the petitioner to believe such vessel would not be delivered in due time, but the same was never delivered. It can't be respondents, it has to be respondent number 3 because your contract was with respondent number 3. Now, my lords, straight, let me come to para 41. Again, I'm just reading the first line so that the court has the perspective of what I want to, my lords, stress on. Para 41, page 26, bottom of page 26 is para 41. Due to breach of the terms by respondent number 3. So again, respondent number 3, para 42. Therefore, the total amount of petitioner's losses is US dollars 1,615,290.26, euro equivalent so and so, which is solely due to the breach of charter party by respondents. Again, in plural, it has to be respondent number 3. Please see para 45. Thus, respondents are liable to pay a US dollar sum of 1,615,290.26. My lord, it has to be respondent number 3 because he is breached. Now, my lords, lastly, please see, and I must, para 50. This is their case. I will not demonstrate with direct law that this is incorrect. This judgment is the judgment of the Bombay High Court. Further states that an in rem action is permissible for the purposes of obtaining security in a case where arbitration has been invoked or yet to be invoked. Thus, it is just, appropriate and necessary for respondent vessel to be detained by an order of arrest until the petitioner's claim is realized or sufficient security is given by the owners or parties interested in the vessel. It is therefore submitted that mere existence of an arbitration agreement will not take away the right of the petitioner to proceed against the respondent vessel in an action in rem. Then, my lords, just see para 58 at bottom of page 34. But I'm just coming to the end of this. Para 58 at the bottom of page 34, your lordship, in these circumstances, petitioner submits it is just, proper and necessary for the court to pass an order and decree in favor of petitioner against respondent vessel and for the master and her owners and or manager and or operator. So you don't know who your case is against, you make the world a party. You say owner, charterer, master, this includes servants, and for a claim of this amount. And now, my lord, your lordship has seen the prayers. I will not bother the court, my lord, waste the court's time on this. The court's question was, where is, your lordship, who is the party to the contract? They have admitted I am not a party to the contract, but let's see the contract for a minute. Your lordships will find the terms of the time charter party annexed by them at page 7070 of the petition.
Yes.
Your lordships will find this charter party is concluded in Hamburg on 6 January 2023 between, now please see who are the parties. Continental Dry Bulk Limited. Please note the next word is important, as disponent owner. Sorry, I'm so sorry. Page 70. Please indicate, my lords, if I'm going very fast, my lords, I'll try and slow down.
Yes.
Page 70. This charter party is made and concluded at Hamburg on 6th day of January 2023 between, please note the party, Continental Dry Bulk Limited as disponent owner. So defendant number 3, who is disponent owner. We'll see, my lord, what does disponent owner mean. And second party, my lords, line number 11, your lordships will find the petitioner's name, Zurbagan Shipping LLC. So this is a charter party, is a contract between the petitioner and respondent number 3. My lords, then So this is, my lords, the contract which is breached by respondent number 3, for which they claim liability is mine. Now, my lords, before I come to the law, with this in mind, may I invite my lords' attention to section 5 of the Admiralty Act. Sorry, I'll start with section 4, my lords.
Yes.
So as to be not, I need not be unfair to them. And my lords, in all fairness, I will demonstrate that their claim qualifies as a maritime claim. The first, my lords, definition of maritime claim, your lordships will find in section 2, subsection F of the Act. It defines what is a maritime claim. Maritime claim means a claim referred to in section 4. So there are 22 claims which are referred in section 4. Section 4 now, my lords, if I may invite my lords' attention, the High Court may exercise jurisdiction to hear and determine any question on a maritime claim against any vessel arising out of, please see H, their case falls in H, agreement relating to use or hire of the vessel, whether contained in a charter party or otherwise. So therefore, their claim is a claim arising out of a charter party. Therefore, their claim is a maritime claim. I will not dispute this. As an officer of your lordship's court, I have to be fair. But the power to arrest is, my lords, in section 5. That confers the power on the Admiralty Court to arrest. And I am going to read this a little carefully before I come to case law. Arrest of vessel in rem. The High Court may order arrest of any vessel which is within its jurisdiction for the purpose of providing security against a maritime claim, which is subject matter of an Admiralty proceeding where the court has reason to believe. So, my lords, keywords are the High Court may arrest for the purposes of providing security of a maritime claim, to secure their maritime claim in Admiralty proceedings where the court has reason to believe. Now, let's see what it has reason to believe. A, the person who owned the vessel at the time when the vessel, at the time when the maritime claim arose, is liable for the claim and is the owner of the vessel when arrest is effected. So very important is that your maritime claim has to be against the owner of the vessel. It mentions 2 stages. When your maritime claim arose, when the contract was breached, their maritime claim arose. At that time, whoever is the owner of the vessel, he should be liable. But he should also be the owner at the time when the arrest is effected. There is no change. So therefore, their maritime claim has to be against the owner. Now B, the demise charter of the vessel. Please note this word because there are 3 types of charters which I will show law on: time charter, voyage charter, and demise charter. In time and voyage charter, it's like, as I had indicated, like leave-in license where the owner is in control of the vessel. The master and the crew is of the owner. But they only have the right to indicate to the master on navigation what to do, where to do. They can contract of the vessel, but there is no vested right. Whereas in a demise charter, there is, this is like a lease. Now, to give an example in property law, where an interest is created, the demise charterer can change the flag of the vessel, can change the whole crew, keep his own crew. So it's, as the Supreme Court says, it is a de facto owner, not de jure owner. So this is if the charterer is a demise charterer. It is not their case in the petition. And that's why I read the petition, my lords, thoroughly, that the charterer, that defendant number 3 or respondent number 3 is a demise charterer of the vessel. They use the word disponent owner, rightly so, and I will show that, my lords, in a minute. And if need be, if the court, my lords, should the court have any doubt on this agreement, that agreement can be produced whenever the court feels. I don't think, my lord, that case is necessary to show that he is always a time charter. My lords, B is demise charter of the vessel at the time when the maritime claim arose, is liable for the claim, and is the demise charterer or the owner of the vessel when the arrest is effected. So you can arrest a vessel for the liability of the demise charterer, not a time, not a voyage. C, claim based on mortgage. Their case is not on mortgage. D, claim related to ownership and possession, not their case. E, claim against the owner, demise charterer, manager, operator of the vessel is secured by maritime lien. Their case is not of a maritime lien. I will show what is a maritime lien under section 9. So the only case that can fall is that provided the liability is of the owner. Now, just, my lords, within a minute, I will indicate. First, give me the encyclopedia. The marine encyclopedia, because, my lord, one needs to be clear what exactly is disponent owner. This is not a concept used in demise charter, because disponent owner will not, my lords, once he's given the vessel, you virtually give the right for the vessel for that period. You have no, in that sense, control. One copy, Maitreyi. What happened? Maitreyi, can I drop it to you? No, it's there. So, my lords, the marine encyclopedia for a moment. I have given, my lords, where I have taken this from. And my lords, please see at the page, the last page of what I had given. Please see, my lords, in the middle of the page on the left is disponent owner. Example, time charterer of a ship. An operator entitled through charter arrangement to exploit the ship commercially. It is generally used in terms of time charter, and I will show, my lords, a direct, if need be, my lords, on this, if there is a dispute on this, a direct Gujarat High Court judgment that it is accepted that disponent owner is time charter. That's one. Now, my lord, therefore, we are looking at their claim against a time charter. In teeth of this, my lords, a direct judgment. First, I'll start with a judgment of the Telangana High Court, or rather, the Andhra Pradesh High Court at that time. It mentions, my lord, the High Court of Hyderabad, for, my lords, when it was a common state for, my lords, Telangana and Andhra Pradesh. Just, my lords, before I believe the bifurcation.
Because there is no Admiralty jurisdiction to Telangana High Court.
Now it does not. But, my lords, I remember, my lords, in courtroom 9 on the ground floor of the Hyderabad High Court, appearing before his lordship, Justice M.S. Ramchandra Rao, he used to sit, my lords, right down on the ground floor, exercising Admiralty.
That's court number 10.
That's, oh, sorry, court number 10. Court number 10 on the ground floor, which was then went to Justice M. Sitaramamurthy, Justice Naveen Rao. But, my lord, that court did exercise it. In fact, the birth of Admiralty jurisdiction started with that, because the judgment of the Supreme Court in M.V. Elizabeth started from, my lords, the Andhra Pradesh High Court. Here. Sorry. Single. Just so that, my lords, I explain what section 5 is and how, my lords, the liability of the owner is very essential. May I straight take, my lords, to, my lords, para 34. But this was a case, just so that I save the court's time. Bunkers were supplied to the vessel. Bunker is fuel. The fuel was supplied at the instance of the time charterer of the vessel, where the time charterer who was given the vessel to commercially exploit amidst voyage required fuel. So he contacted a bunker supplier, asked him, please supply me bunkers. It was supplied to him on credit. Later, he defaults. The vessel was arrested. The registered owner comes and says, sorry, your liability is against him. You can't arrest my vessel. Now, in teeth of this, please see, my lords, how the court deals with this. Para 34. If one, sorry, your lordships will find that at page 11. If one were to look at the definition of maritime claim and its elaboration in section 4, a claim for interest on a principal amount towards supply of bunkers by a bunker supplier to a charterer is not a maritime claim prima facie. So under section 5, the High Court may order arrest of any vessel which is within the jurisdiction for the purpose of providing security against a maritime claim, which is subject matter of Admiralty proceedings, if the claim of the plaintiff is not in the nature of maritime claim, prima facie there could not have been an arrest of the vessel by the High Court in Admiralty jurisdiction. More so, under 5(1)(a) can be made only if the person who owned the vessel at the time when the maritime claim arose is liable for the claim and is the owner of the vessel when the arrest is effected. Or under 5(1)(b), please see the next word, demise charterer of the vessel at the time when the maritime claim arose is liable for the claim and is the demise charterer or the owner of the vessel when the arrest is effected. In the instant case, first defendant vessel contains the vessel was on time charter with third defendant. Please see, like us, time charter with third defendant. When the bunker supplier was made by the plaintiff to the vessel, they contend at that time when the bunker supply was made, bunker delivery note so-and-so constrained an endorsement that by the engineer of the vessel stating that expressly goods or services are acknowledged and received for and ordered solely to the account of the charterers of MV Kiveli and not on the account of the vessel of the owner. Accordingly, no lien or claim against the said vessel can arise. It is their contention that the plaintiff was fully aware that the owner was and only on account of the charterer. Therefore, sole liability for the cost of the bunker is that third defendant and not first defendant. So therefore, not the vessel for the liability of the time charterer. Learned counsel for the plaintiff sought to contend that notwithstanding the said endorsement bunker delivery note, the liability is that of the owner, first defendant. Since master of the vessel was acting on behalf of first defendant, he took delivery of the bunkers. The contention of the plaintiff is not tenable for following two reasons, very important. First, because there was no privity of contract between the owner of the vessel and the plaintiff. There is thus no contractual liability on the part of the owners. Secondly, as a matter of law, necessaries supplied to a ship, though prima facie presumed to be supplied to the credit of the ship, such presumption cannot be drawn in face of the material on record showing that the parties who supplied necessaries do not do so at the instance of the owner, but the person to whom they invoiced looked alone for the payment. Then, my lords, I will, just to save time, please note in para 40, Gulf Petroleum, the single judge of the Bombay High Court in MT Valor is followed. Please mark this. I'm just, my lords, coming straight, my lords, to the then 42, Justice Shriram's judgment in my lord's flag Mercenary is noted. 43, my lords, again his judgment in Sokar, Turkey. And now please see what is the ratio in para 44. Having regard to the above legal position, in view of the specific endorsement of the bunker delivery note issued by the plaintiff's agent, which was signed by the engineer, the bunkers were received solely on account of the charterer and not for the account of the vessel or an owner. I hold prima facie there is no liability of the owner of MV Kiveli. And if there is any liability, it would be of defendant number 3 alone only. Consequently, I am of the opinion plaintiff had not made out a case even for initial arrest of the vessel MV Kiveli for the aforesaid reason, and the arrest.
And before that, the court felt that it is not at all a maritime claim at all.
Yes, but my lord, it then dwells into the fact, the second limb of the argument, that this is only for the liability of the charterer and not that of the owner. And on that ground, my lords, it vacates. In fact, it goes on and orders counter security, which is my next application. But at present, my lords, for this purpose, I'm seeking vacating. This was upheld, my lords, by the division bench on a different proposition. I'll tender that. Justice Suresh Kumar and Justice Gangarao. I'll tender that judgment, my lords. Judgment upheld by the division bench. The second judgment that, my lords, on this proposition is a judgment very recent of the Gujarat High Court, for which, my lords, I had the privilege to appear in appeal. Well, I'll just indicate judgment of Her Ladyship Justice Gokani, which not just discusses, my lords, what is the jurisdictional test, but it says at an interlocutory stage what all can be done. I am conscious of the court's time and I am going to only cite the relevant portions so that, my lords, I save the court's time. May I straight invite my lord's attention to para 33.9 at page 37. Your lord, sorry, page 37, it's at, my lord, the top of page 37. 33 section 5 permits the High Court to order arrest of any vessel in rem which is within the jurisdiction for the purposes of providing security against a maritime claim which is subject of Admiralty proceedings, where the court has reason to believe that the person who owned the vessel at the time when the maritime claim arose is liable for the maritime claim and is the owner of the vessel when the arrest is effected. 5(1)(a) of the Admiralty Act thus clearly provides that the court having jurisdiction to arrest the ship should have a reason to believe that the owner is liable to pay to the plaintiff. So the liability has to be that of the owner. Then, my lords, please see, I will skip 34 for the minute because that deals greatly to say how the new act changes the position. Please see now, my lords, from para 35, it explains, your lordships have seen when I read section 5, the court needs to have a reason to believe. Your lordship knows, my lords, reason to believe is a terminology also your lordship has come across in Income Tax Act, when under 143 of the Income Tax Act, when there is reopening of assessment, the language is the tax recovery officer needs to have a reason to believe that the tax has escaped, my lords, the assessment. Same language, my lords, used in Admiralty Act. The court draws this as a parallel, that their reason to believe means there has to be some material produced to the court, and that material should be the basis to indicate that the owner is liable. That is para 35. And therefore, my lords, your lordships will find in para 35.1, the judgment of Supreme Court in Aslam Mohammed Merchant versus Competent Authority. And then, my lords, your lordships will find in para 35.2 Sikkim Subba versus Union of India. This is, my lords, on income tax. Your lordships will also come across reason to believe in section 29 of IPC. There is similar language in under the PMLA Act, using this word that there has to be some material before the court for the court to look at the material and come to a conclusion that the owner is liable, even for at a prima facie stage. This is what, my lord, the Gujarat High Court says. Now, whilst holding this, it says, please see 35.3. This is, I'm just summarizing this for the court. Thus, on the basis of, on the basis of reliable, relevant, and specific information and details furnished to the court, it needs to have a reason to believe that the owner is liable to the plaintiff. And for arriving at such satisfaction, evaluation of information and material is a must, as pointed out, that the information would be such that would provide a live link or a rational connection between the information and formation of the belief. Thus, unless the court is satisfied that the owner is liable, the arrest of the ship should not be permissible. Being a very serious remedy, it has been examined while adverting to the facts of the information and material placed before this court contained were relevant, specific to arrive at the belief that the applicant defendant is prima facie liable for the claim advanced by the plaintiff while seeking the arrest.
Is a contract period between you and the third respondent?
Oh, I'm sorry, my lord. May I beg your lordship?
Respondent number 1
my lord,
and respondent number 3.
is a time charter party.
Time charter. There must be a time schedule.
So they
for
have
that?
been given this vessel to exploit for a period of around 6 months to commercially exploit this vessel.
That's between, what is the time?
My lords, just give me a minute. I will, my lords, my colleague assisting me will indicate the date whilst I'm reading the next portion, but I will answer the court's question, my lords, positively before I complete the next paragraph. Just check the time and let me. My lords, next, before venturing in, may I now trouble the court, my lords, by reading para 40 of this judgment. Or rather, my lords, para 41. 41 is more, my lords, on 41 only says, and please note this, my lords, I want to really save the court's time. The court has been kind enough to give me time. Para 40 says supply of bunkers is not a maritime lien. Because if you look at maritime liens, they are, my lords, enlisted in section 9. A dispute under charter party is not a maritime lien. So, my lords, next is, my lords, para 42. It would be, this is very important because this was also a liability of the time charter. It would be appropriate at this stage to inquire about the ownership of the vessel, since personal liability of the ship owner is necessary for arrest of the ship. The plaintiff has supplied the bunkers. Please note, my lords, the next word, to charterer at the instance of Bohai on 30 days credit. The charterer has defaulted in making payment of the bunkers supplied for the purposes of voyage. According to the plaintiff, he is not supposed to be aware of the agreement between the ship owner and the time charterer. Therefore, once the bunkers are consumed by the ship for its voyage, the master of the ship accepts it without murmur, and the responsibilities of the ship owner, this was the argument, responsibility of the ship owner, whether its conduct, the ship owner sufficiently put the plaintiff to notice at any time, charter agreement, etc., as a matter of trial, is a matter of trial. Now, please see 43. According to the respondent, the identification of the owner of the ship is extremely important, and bunker supplied is required to take adequate precautions to ascertain whether the owner of the vessel, in fact, had ordered the bunker, and there are methods for ascertaining the details. According to the applicant, defendant, prudent bunker supplier should be demanding the payment immediately upon and security from the charterer. and making supply and granting credit in respect of the credibility. One may not prove to be correct always to ascertain the details. Then it follows, my lords, the English judgment of the Yuta Bodavarsky. Now please come to 44. The Supreme Court judgment in Chrysomer is noted only to say that bunker supply is a maritime claim, not a maritime lien. Now, my lords, please, if I may invite my lords' attention to, my lords, para 45.1. The provisions incumbent upon the register. But this just, my lord, please mark it. I don't want to waste your lordship's time. This says that, my lord, how we ascertain from registered agreement who's the owner of a property. Likewise, for a vessel, wherever the vessel, the flag of the vessel, there is, my lords, a register. You go to the country of register, you open the flag, you open the register and see who is the owner. So it is something, an exercise that every party who has a claim against the vessel has to do. You have to ascertain who is the owner of the vessel. Then, my lords, please see para 46. In the instant case, the supply of the bunkers admittedly was ordered by Bohai at the behest of Liani. Bohai is the agent of Liani. Now, my lords, 47. The moot question therefore remains to be addressed is whether the correspondence which has been entered into Liani and plaintiff opponent is sufficient to reveal clearly and unequivocally the order of supply of bunker exclusively by time charterer, very important, and after ascertaining on the part of the opponent plaintiff before supply of bunker, this deal is made. This comer needs to examine, this court needs to examine as to whether it is apparent without detailed probe that it having knowledge of the ship, having registered in the name of the applicant owner, has chosen to suppress all aspects and obtain arrest without disclosing of this vital fact. The law is been very clear that in personam liability of the ship owner is a must for the payments to be made for the bunker supply for the vessel, and the correspondence between Liani and plaintiff and some other documents which have been brought on record shall be vital for the court to examine at this stage. Then, my lords, if I may invite my lord's attention to para 50 at page 80. It is averred in para 5 on and around 17/5/2018. My lords, just third line of that para. Bohai on behalf of the defendant vessel master and or owner and or charterer and or manager and or operator, just, my lords, as they have done, approached the plaintiff for supply of 400 to 600 metric tons of fuel to the defendant. It is averred that bunkers were supplied to the defendant vessel at the instance of the owner at the faith and credit of the vessel and had consumed the bunkers which is necessary for the operation. The plaintiff is therefore requested to consider the vessel only. The plaintiff also pleaded maritime lien and then the agreement. Then, my lords, may see straight how the court, what the court ultimately observes in paragraph number 54. It comes to a conclusion that the court was hoodwinked. The fact that actually the supply was at the instance of the charterer. Para 54. It is in this background, material on record deserves a closer look. It is quite clear from the email sent where subject order confirmation shows that the head owners have bunker non-lien clause and they need confirmation. This has been addressed to the plaintiff. Dan bunkering, which provides Bohai orders, it is quite clear. Thus, the charterer of Sylvia Glory, the email has been addressed to the plaintiff, where it has made clear that the head owner is a bunker lien clause. It has also made clear at the discretion of the charterer that the bunker was requested for MV Sylvia Glory. It is also noticed that the bunker delivery receipt specifically provided bunkers were acknowledged and accepted for the account of time charterers of Liani and not on account of the said vessel or her owners. According to it, no lien for the said vessel or the owners can arise. Against this, it is not disputed. The best excellence in this case was the owner, has never sent any confirmation in the name of the agent. This court noticed various correspondence which has been addressed between plaintiff and charterer, where eventually the offer of settlement by Liani is also made as dispute arose between the quality of the bunkers and consequently the issue of non-payment of the amount of consideration to the seller. Thus, admittedly, fuel was supplied on so-and-so and on so-and-so. Dan bunkering received a message. It was mentioned that the bunker fuel caused additional machinery breakdown. However, clause 12.2 provided the claim for the quality of the bunker to be brought. But just see 3 lines thereafter. Thus, it is the say of the plaintiff that the claim being brought within the notification period is necessary as the procedure set out in clause 10 of the terms. Such samples retained by the seller shall be tested. Now please come, my lords, to para 57. The present suit has been filed on 5th of February 2019. Order was obtained on 6th of February 2019. It is quite clear the correspondence entered into between the plaintiff and liani that the charter party contract is not having a clause of lien so far as the supply of bunker is concerned, but that having specifically been conveyed, it is the charterer alone which is responsible for the payment of supply price of the bunkers. The parties negotiated where disputes and of quality were raised. They do have an arbitration clause, and yet attempt was made by both parties to settle the dispute negotiation. It is thus emerging from the record that plaintiff has been made aware emphatically by the charterers, leaving no ambiguity on this aspect of its existence of maritime lien against the vessel. Please come, my lords. Then thereafter, to para 58, but the last two lines, and if such averments is accepted, the same would amount to permitting the plaintiff to disown its own correspondence. Correspondence through email unequivocally reflects that the plaintiff not only was put to notice by the charterer that it is not the owner and is placing the order of the bunker, but also has been made aware of the owner refusing to have any clause of lien on the vessel for unpaid bunkers to the charterer or anyone on his behalf. So, my lord, in this case also, the liability was of the charterer for which the vessel was arrested. Please see, my lords, what ultimately the Gujarat High Court does, last 4 line of that page 90, to say Chrysomer's decision was taken in change of ownership, it would have binding effect so as to this matter is concerned cannot be countenanced. Decision of Eco Maritime, the apex court may not have made any change in the decision of the division bench of this court. Therefore, findings of the division bench need not be regarded overlooking the ratio in Chrysomer in view of the distinct fact. Do not find favor. My lords, 59, this is possibly the second last paragraph, and I'm done. It is quite clear from the discussions herein above, plaintiff, if had chosen to invoke clauses of standard terms and conditions, my lord, this standard terms and conditions is not in the present case. I can skip. But your lordship, my lords, I'm showing it for completeness. Para 60. This is one of the instances where rightly pointed out by this court, the very fact that liani is a time charterer and having sole responsibility to pay bunkers may be supplied to it had become absolutely clear prior to the plaintiff having initiated action against the applicant defendant, which is the vessel. As in other cases, none of these details is in the realm of question raising tribal issue. This being virtually clear case of knowledge of the plaintiff as to who is responsible for the demand of outstanding sum of the price of the bunkers, it cannot be permitted to drag a third party into litigation. It is also noted at the time the present suit has been filed, new Admiralty Act 2017 had come into effect, come into being, and the court is not in agreement with the submission of the plaintiff that it has changed nothing. It is in the agreement, it is in agreement with the submissions, and the ratio laid down in Chrysomer will have no applicability on the present case, since that can operate where the question of change of ownership, wherein in the instant case all throughout since 2012, the ownership of the vessel continued with the applicant defendant. Equasis is also quite clear, leaves no doubt of ambiguity in respect of the ownership of the vessel. That's the first document, my lords, I showed. Equasis, who is the owner of the vessel. Ultimately, my lords, in para 60 towards the bottom, the court vacates the order of arrest and directs security to be returned to the owner. That's exactly my application. An appeal against this was preferred. That appeal came to be unconditionally withdrawn. One last judgment, and then I'm going to only tender judgments with the paragraph so that I don't waste the court's time. On this principle, and I'm going to show a very authoritative view of His Lordship Justice Sriram of the Bombay High Court, where, my lords, this entire issue was discussed. And, my lords, flag Mercini. And the court says ultimately, personal liability of the owner is a sine qua non if your claim is against the time charterer. And it says it in so many words. You cannot arrest the vessel. And, my lords, that's why, my lords, I did begin by showing the entire plaint of the plaintiff. Their claim is against respondent number 3. They termed respondent number 3 as the charterer. And, my lords, yet all throughout in their plaint and even in the reply or the objections filed to the IA, they say that, no, sorry, even if the liabilities of the charterer, I am entitled to arrest. Lords, at times, there are funny arguments taken. In this case, I must only indicate the vessel is treated as a juristic entity for a very limited purpose. It is treated. So in this case, bunkers were supplied to the vessel, and an argument was proffered to the Bombay High Court saying, see, listen, I supplied the bunkers to the vessel. Vessel is a juristic entity like a company. So vessel is liable. So I can arrest the vessel, which was rejected. And Justice Sriram says that what is essential is you need to have a privity with the owner. And that's where, my lords, what I wish to, my lords, highlight para 27. At, my lords, page 6, para 27. Mr. Dhond further submitted that the transaction in issue was admittedly for supply of bunkers which was supplied to and received by the vessel. Because the vessel received the bunkers and under maritime law, ship has an independent juristic personality, independent from its owners. A subsequent disclaimer by the master of the vessel is of no avail. According to Mr. Dhond, moment supply is effected, contract between the plaintiff and the said vessel sprang into existence. And Mr. Dhond submits that whether the disclaimer endorsed the vessel or a preemptive avoidance of such a disclaimer described the plaintiff would prevail can only be decided at trial. As the plaintiff has in terms and conditions mentioned about US law applicability and defendant number 2 has accepted the same, US law must be enforced and there is privity with the vessel. The owners, namely defendant number 3, cannot argue that there is no privity and hence US law is validly incorporated and applied. So, my lords, an argument also made that I have privity with the owners. Now, please see in para 28. I totally disagree with Mr. Dhond. A vessel cannot enter into any contract with anybody. Only an owner or a person authorized by the owner can enter into a contract and bind the vessel. In law, a vessel may be looked at as an independent juridical personality, but to say that there is privity of contract with the vessel and not with its owners is stretching it too far and is incorrect. An action in rem against the vessel can be maintained, please note this, can be maintained only if there is an underlying obligation of the owner and an action in personam is maintained against the owner. A contract is between the plaintiff and defendant number 2. Copy of the contract has not admittedly been sent to the owner, like in this case, not sent to me. There is not even an averment that the owner, defendant number 3, has held that they will be bound by the terms of the conditions of the contract that has been accepted in between the plaintiff and defendant number 2. Therefore, it can never be accepted that US law is applicable vis-a-vis plaintiff and defendant number 3. Mr. Dhond submitted that under law applicable in America, but then American law is discussed and held that Indian law is different than American law. Please come, if I may invite my lord's attention, straight to my lord's para 38. The admitted position of the vessel. I'm sorry, my lords. My lords have? I'm sorry, my lords.
What about 33?
I can read 33. In the present case, the court came to a conclusion. Then when the supplier knows that the ship was on charter, very important. I'm grateful to the court. The supplier ought to take steps to ascertain whether the charterer, that is defendant number 2 in that case, had authority from the owner to contract on their behalf or to bind the ship. The court made that remark because general terms and conditions in that manner, like in the present case, had recognized the possibility that the bunkers may have been ordered by and on account of the charterer who had no authority to bind the ship. In this case also, the terms and conditions of 5.2 provided that the party requesting the bunkers are not owners, the bareboat charterers or of the vessel. The seller shall have the right to insist on precondition of the sale that the payment guarantee by the owner or the bareboat charterer had the right to cancel the agreement with the buyer. And if payment guarantee is not received, the request thereof from the seller to the owner of the bareboat charter, the admitted position is no such request was made to the owner. Like in this case, it's not their case that this agreement was sent to me for my imprimatur, that I say, yes, you can execute such a charter party, and if you fail, I am liable. In that case, of course, I will be liable. But it is not their case, rightly so, because no such contract was ever sent to me. Now, please see, my lords, 38. The admitted position is that the said vessel was on time charter to defendant number 2. It is universal knowledge that time charter, the bunker is supplied by the charterer. Mr. Dhond has also agreed to this. Ordinarily, it is the charterer who provides and pays the vessel's bunker while the vessel is on hire. It is for that reason the plaintiff has inserted clauses like so and so in general terms and conditions. In my view, the plaintiff was satisfied with the creditworthiness of defendant number 2, that is the time charter, and hence did not ask for guarantee from the owner, defendant number 3, more so due to earlier dealings with defendant number 2. Otherwise, either the owner would have guaranteed the payment or the plaintiff would have not supplied. If it had proceeded on the basis that the sale was on credit of the supply and guarantees a creation of a lien on the vessel, the value of the bunker delivered, the owner would have objected through the master by putting a rubber stamp of on the delivery receipt. The rubber stamp expressly provides the bunker were accepted exclusively for the charterers and not on account of the vessel for the owner, and no lien or other claim against the vessel or the owners can arise therefrom. When an owner made it very clear that it is not going to pay for the bunker and the vessel is also not liable, which is contrary to the representation made by the defendant number 2 that he had authority to bind the vessel with a maritime lien, the plaintiff ought to have protested. There is not even a shred of evidence to support that plaintiff protested. The plaintiff had only submitted insertion of the contract for supply should prevail. Therefore, the only option the plaintiff had is to go against defendant number 2, that is the time charterer, for misrepresentation. My lords, then para 40 and 41. In this case, it is not even the averment of the plaintiff that plaintiff made an attempt to contact the ship owner, defendant number 3, as to ascertain whether defendant number 2 is authorized to purchase the bunkers on their behalf. In view thereof, the only inference that could be drawn that the plaintiff did not make such an attempt, particularly because it had an option to do so. It printed terms. The defendant number 3 by its conduct or behavior indeed think that defendant number 2 was authorized for them to purchase bunkers on their behalf. It is significant. Please note, Miller, I'm just not marked 41. I'm just saving the time because that's in facts. See 42. Since there is no contract between defendant number 3 and the plaintiff, defendant number 3 in that case was the owner, and the plaintiff, defendant number 3 have not by their actions or conduct misled the plaintiff into belief that defendant number 2 was authorized to act on their behalf. The choice of law provisions, namely 14.1 in general terms and conditions of the sale and delivery, namely entered into between the plaintiff and defendant number 2, should not be given any weightage. My lords, your lordships will see in para 44. In this case, my lords, the notice of motion was allowed. It was the maritime claim argument was rejected, and my lords, in addition to that, security, a cost of rupees 2 lakhs was imposed on the plaintiff because, my lord, this is a drastic action, and that to obtain ex parte. I have, my lords, this I have shown, my lords, if need be, I'll, my lords, prepare a note in which I'll, my lords, provide all judgments with the relevant para numbers so as to not waste the court's time. Just, my lords, to summarize myself on this proposition, the court, my lords, it is imperative that a party either shows 2 things, and I must stipulate as an officer of your lordship's court. First, that the petitioner is obliged to show that there is a privity of contract with the owner of the vessel and show that he is liable. Second, he must show that he can't just merely surmise. He must show that his claim is against the demise charter, not one word in the petition which says that it is not. And that is why, my lords, they are very clear that defendant number 3 is a demise charter. The moment they don't say this, 51B cannot be invoked. If 51A, 51B can't be invoked, as his lordship, then, my lord, Justice M.S. Ramchandra Rao rightly holds in M.V. Kiveli's judgment, which I tendered first. If the test is not satisfied, there is no question of arresting, my lords, the court exercising arrest. And therefore, on this ground, my lords, I am of the, in my respectful submission, my lords, the arrest has to be vacated. My lord, there are multiple judgments of the Bombay High Court. I'll, my lords, tender a compilation with the relevant page numbers. I'll give my friend a copy so that my friend can put in a note, my lords, distinguishing if she, my lords, chooses. Now, my lords, second aspect, I had indicated, my lords, 2 things when I read the petition. There were 2 material false statements made. First, they say that in para 4, they represent some quangdo as to be the owner of the vessel when their own document shows that the owner of the vessel is CS Flourish Limited. The second is of a far more serious consequence, which I had pointed out, where they say respondent number 3 is the owner of the vessel. Why do they say so? Because they know that to pass the muster of jurisdictional test, they must show the liabilities of the owner. It is for this reason they say respondent number 3 is the owner of the vessel, despite their own document showing it to the contrary. And my lords, I just didn't want someone to say, to obviate this possibility of someone saying equaces, oh, my own document, I could be wrong. I have produced a certificate from the registry where the vessel is registered to show who the owner of the vessel is. May I only trouble the court with, my lords, my eye at page number 19, only for this one moment, and then one more aspect, and then I'm done.
Page number?
1919, madam.
IA number, sir.
I number 1, madam.
Of 24.
The court asked me a question, my lords, when I was reading a judgment. I am duty bound to answer that. I've made a note. I will show this and I will answer that court's query. This period for 50 days.
Yes. Page number?
My lords, 1919 R1. It's annexure R1 to I1.
These 461s are here.
May I assist the court, my lords, in pulling out that page if the court.
So, tying up all that, we can keep it separately.
Sure.
Yeah, but annexures, all IAs are kept separately. Their annexures are held separately. Here, this is the one. Yes. Page 19. Yes. Yes. Show the full her lordship this.
Yes.
This is page 19 of this. I and your lordships will find on the top, Republic of Panama. It's registered in Panama, Republic of Panama. Name of the vessel in the center, CS Flourish. General cargo, cargo general vessel. Please see registered owner in the center, CS Flourish Limited. In the center of the, here, my lords, here. Here in the center of the page. Just below, my lords, navigation statutory register.
CS Flourish.
Yes.
Cargo General.
Yes, CS Flourish is the vessel, and just below that, CS Flourish Limited registered owner. So no doubt in anybody's mind who the registered owner is. Despite this and their own document, they, my lords, had the temerity to in fact plead in their petition that defendant number 3 is the registered owner. I have, my lords, pointed that out. But apart from this, I must say there are two aspects, and quite seriously, for this claim, the petitioners herein had moved, my lords, Russia. And this is, my lords, in additional. They moved Russia, where this vessel before the arbitration court there was arrested. The owners then appeared and made an application to vacate the order of arrest. That application was allowed. And I must only point out, I'll give my lords the page numbers. That application came to be allowed by a judgment of 26th of June 24, a month before arrest took place here. And at the time when arrest was made, and I'm going to indicate, my friend need not worry that about the appeal proceedings, but at the time when the arrest was obtained, the judgment of the Russia's the order of the Russian arbitration court held the field, which observed that the vessel could not have been arrested. This document was conveniently suppressed from the petition. And my lords, I'll cite, my lords, a direct judgment of the Supreme Court, where the Supreme Court says it is not the option of the party to select what it wants to cite and what it should not. And they, of course, now for the first time in their reply, rely upon an appeal court order with some translation from Google, possible. Even if let me proceed on the basis that I trust them. The appeal court makes certain observations on the findings of the first appellate of the arbitration court, ultimately dismissing the appeal because the vessel had left. So the order of the court at the time of obtaining the order of arrest should have been shown to the court, because, my lords, this order of the appeal court that they wish to rely upon came 3 months down. My question is, I asked myself a question in form of a rhetoric, that had this document been shown to the learned judge who granted an ex parte arrest, would the judge have granted this ex parte arrest to them? But this fact, for convenient reasons, was suppressed. And that's why the timing is important. If I may only request the court to note, the date of the order of the Russian court is 26th of June 2024. 25th of June 2024, I'm sorry. Which your lordships will find in the same compilation at page 74.
The order of?
Russian court vacating the order of arrest and allowing the vessel to set sail. The court very pertinently asked the question at the beginning of the matter, what is the date of grant of the order of arrest? The date of granting the order of arrest was 24th of July 2024.
No. 25th June, vacated there. Then what about the appellate court's order?
Appellate court's order, which they have annexed now for the first time in reply, is 5th of September 2024.
5th of September?
2024. And the order of arrest granted by our court is dated 5th of August. Oh, sorry. 24th of July 2024. So at the time when the arrest was granted, there was no appeal order.
No, you are saying it is on 5/7.
5/7 is the, my lords, no, I'm sorry, my lords, I'm sorry. Let me clarify.
Appellate court's order.
Appellate court's order is 5/9/20. So at the time when the arrest was granted by a lordship's court, the order of the first, and I don't think, my lord, that position has changed. In light of the appeal, for whatever reasons, having dismissed, I'm not saying, my lords, they've rightly said in their reply or in their objections, this does not constitute res judicata. I'm not saying it constitutes res judicata. I'm not even saying that the Russian court's order is a reciprocating.
The facts needs to be placed for the court.
Should have been produced before the court. I'm not, my lords, therefore I did not want the court to feel that I'm vilifying their deplorable conduct as the only basis to seek an order, to seek vacating the order of arrest. That is an additional point. But primarily, what I wanted to satisfy the court was on what is the case with which the party has come before your lordship's court. Whether that meets the jurisdictional test. And, my lords, without even avering, and of course, I am yet to hear my friend on this, because she says for a disponent owner, it is capable of being arrested. I'm yet to see some law which, my lords, of course, my friend will cite. And we'll deal with it if need be, because I'm yet to come across, my lords, a judgment which says for a time charterer's claim, liability, the vessel can be arrested, at least not in India, at least not in England, and certainly not in Singapore. I can say this with an element of certainty. I will show, my lords, if subject to hearing my friend, if she has to argue that it is a disponent owner, because then, my lords, there is sufficient number of authorities on that, at least of courts in India, to say that what is the test that is need to be. And, my lords, I will cite that if need be. My lords, what is important is therefore 3 tests to summarize my arguments. First, test not satisfied. Second, I've shown at least 2 instances where false statements have been made. Third, documents have been suppressed. My lord, is this, my lords, would the court, my lords, I ask myself this question, would the court would want to sustain an arrest at the instance of the party who comes to the court with, my lords, incorrect submissions on facts, suppressing documents because it is not convenient. And that's why I gave that the court the timeline. Appeal court's order, which is now sought to be, I'll show the appeal court order. The appeal court makes, subject to that being correct, because the translation provided by us is a certified translation, that is a Google translation, but I'm saying let me accept what they say. Ultimately, what is the net effect? The net effect is that the Russian court in appeal has dismissed the appeal which means the order passed in my favor has not been reversed for whatever reasons. Should it not be, my lords, expected of a party coming to a court citing this to at least demonstrate bona fides? I can understand if the court is shown this.
The arbitration pending now.
Arbitration is not between me and them at all.
No, whatever arbitration.
I don't know, but from what I gather, it's pending in London. So imagine, my lords, a situation, arbitration between two parties to which I am not a party. I can't even defend myself in those proceedings. The liabilities of someone else, but for that my vessel is arrested. And my lords, we therefore have a law which in my respectful submission is completely breached. Lastly, the court asked a very pertinent question. Your prayers, when the court looked at the prayers, your interim prayers and final prayers are the same. Can this be the case? My friend said, no, it is all obviously done in this fashion. I am to show, my lords, two judgments of the Bombay High Court. I can understand if there was a prayer for a decree in the present case, and I understood where the court came from, because that is precisely what the law is. In fact, the two judgments that they have referred to in Altis Uber, one of Justice Sriram upheld by Division Bench of Justice Dharmadhikari, both were instances where decree was sought. A full bench of Bombay High Court is relied upon them. It was a case where decree has been sought. Now let us look at a scenario or judgment where decree has not been sought and where the only relief sought in a petition is an interlocutory relief. Because your lordship has the Admiralty Act, please see section 12. Section 12 of the Admiralty Act says for Admiralty proceedings, CPC applies. Section 12, application of CPC, the provisions of Civil Procedure Code 1908 shall apply in all proceedings before the High Court insofar as they are inconsistent with or contrary to the provisions of this Act. So CPC applies unless they are contrary to Admiralty Act. So therefore, provisions like say section 16 to 20 are not applicable. There is no system of filing a suit where the defendant resides or where cause of action arises, because all that you need to see is where the vessel is. So to that extent, it is inconsistent. So CPC is not applicable. But otherwise, CPC is applicable. You need to at least ask a decree. What happens when it is not? Let me, my lord, cite a direct judgment of His Lordship Justice Sriram in African Eagle, Bombay High Court, my lords. I'm sorry, Bombay High Court in African Eagle. Madam. This is distinguished. I must say, I'm an officer of your lordship's court. I say this responsibly, is distinguished in another judgment, but that grounds of distinction is that there was a decree sought in that case. In this case, there is no decree sought. Please see, my lords, now if I have to trouble the court on the arguments in para, let me read, my lords, the argument of the counsel and straight to the ratio. Para 8. Oh, I'm so sorry. Do we have a better copy, please? Lordship's copy is. Oh, it's stapled that way. I'm sorry. I'm extremely sorry, my lords. Just check, Baba. We can't give a copy. Madam, may I assist? Oh. Once again, my lord's apologies to the court. May I trouble the court with para 8, which is at page 3 of the judgment. Mr. Ramabhadran also submitted that though order of Kathawala J has been considered on the judgment in so and so, probably because nobody had raised a point or brought to the attention of the court, the plaint should be rejected under Order 7, Rule 11A, because the plaint does not disclose a cause of action. He submitted that the plaintiff, in fact, had no cause of action, and therefore the question of disclosing a cause of action also did not arise. Hence, the plaint has to be rejected. He relied on the judgment of the Apex Court, my lords, in the famous Balco case, which is on 5-judge bench on arbitration, which is popularly known as Balco versus Kaiser Aluminium Services, Balco. Mr. Rambhadran, this is important. Rambhadran submitted that the apex court has reiterated the position it was, as a matter of law, an inter-party suit for interim relief pending in arbitration, even if it be limited for the purpose of restraining, dissipating of asset or for security is not maintainable. He submitted that the apex court has held that fundamental to the maintainability of civil suit is existence of cause of action in favor of the plaintiff, and it is evident from various proceedings in CPC, Order 7, Rule 11. He submitted that the apex court in Balco has held that pendency of the arbitration proceeding outside India would not provide a cause of action for a suit when the main prayer is for injunction. I must say, my lords, as a responsible officer of your lordship's court, that law on this has been amended by virtue of the 2015 amendment to the Arbitration Act, which has amended section 2, subsection 2. Now you can file a section 9 in a foreign seated arbitration. But please see ultimately the next page, page 4, such an interlocutory order for security can only be granted during the pendency of the civil suit, claiming a relief which is likely to result in a final decree upon subject which is in dispute. It is submitted that since the dispute is to be decided by the arbitrator, no substantive relief concerning the merits of arbitration could be claimed in a suit, and the plaintiff only claim would depend on the outcome of the arbitration proceedings in a foreign country over which the court in India would have no jurisdiction. Therefore, the cause of action has clearly contingent speculative. I'm sorry, my lords.
Come to para 51.
Yes, my lord. May I para 15, your lordship says. May I just point out 15 I'll read. On Balco relied by Rambhadran and Mr. Sancheti, the
I said 51,
51. Oh, sorry. 51. In the circumstances, apex court has held inter-party suit simply for interim relief pending arbitration outside India will not be maintainable unless the dispute is decided by the arbitrator. Cause of action will clearly be contingent and speculative, and there will be no existing cause of action. The plaint is bound to be rejected under Order 7, Rule 11. In my opinion, the court's jurisdiction to arrest a ship in an action in rem should be exercised for the purposes of providing security for an award which may be arbitration proceeding that is maintainable, because the purpose for exercise of jurisdiction is to provide security in respect of an action in rem and not to provide security in some other proceedings like the arbitration proceedings. If the plaintiff invokes jurisdiction of the court to obtain arrest of the ship as security for an award in arbitration proceedings, the court should not issue warrant of arrest. Just two aspects, my lords, because they have relied upon the full bench of Bombay High Court in JS Ocean Liners. I must only point out that that judgment was considered before this judgment was rendered, which your lordships will find, my lords, JS Ocean Liners, your lordships will find at para 18:18. So that, my lords, it should not be, lest it be argued by anybody that the full bench, how can we rely upon a single judge when there is a full bench saying to the contrary? Please see, the full bench is distinguished in para 18. Just see, my lord, sorry, may I just trouble para 18, 7 lines from the bottom of para 18, your lordships will find, though the court has not in so many words, your lordships has that, my lords, though the court has not in so many words, I would say that arbitration as that an action in Admiralty jurisdiction cannot only for security pending arbitration as the sole relief. The reason for that, in my view, is that the ship may be arrested in Admiralty jurisdiction only to acquire jurisdiction to obtain security for satisfaction of the claim, where decreed or in execution of a decree, once the vessel is arrested, the suit must proceed to trial against the owner as in any other considering the judgment of the apex court in MV Elizabeth. In fact, this is confirmed by the full bench in Golden Progress while considering the judgment of apex court in MV Elizabeth versus Harwan, and in matters of MV Sea Success versus Liverpool and London PN Steamship Protection and Indemnity Association Limited. The full bench has in paras 38 and 30 and 38 observed thus. So the full bench was considered, the Supreme Court judgment in Elizabeth was considered, the Supreme Court judgment in Sea Success was considered. Therefore, in my respectful submission, what fell from the court initially as a query, in my respectful submission, is pertinent. And my lords, then in para 21, again, the full bench is noted to say, reading the full bench judgment the learned judge says you can't read it in piecemeal, read it holistically, and therefore see what he says in para 21. Reading the Golden Progress Supra judgment holistically, it would show that Admiralty Court has no jurisdiction to arrest a ship or keep a ship under arrest when a party who sought to invoke Admiralty jurisdiction not to obtain hearing and determination of the claim, but for the purposes of security for an award for arbitration proceedings. Like in the Golden Progress matter, if a party files a suit in which primary prayer was decree, it is quite possible that the defendant may give up arbitration and proceed to defend the suit, in which event the suit shall be proceeded with, and it cannot be said that the High Court has no jurisdiction, cannot be said that the High Court has no jurisdiction to deal with such suits. This means that the plaintiff may not be keen to go on with arbitration, but may want to go on with the suit, and the defendant may also sing along, in which case the suit may be proceeded with. At that stage, the plaintiff cannot say that the High Court has no jurisdiction to deal with a suit, but refer the matter to arbitration. However, in such suit, if the defendant comes and insists that there must be a valid arbitration agreement operative and capable of being performed, and if that is so, the court has no discretion but to refer the parties to arbitration agreement. It is for this reason Golden Progress holds as follows. Your Lordship knows, my lords, in arbitration, any suit is filed. Once it is converted into an action in personam, depending upon whether it's a domestic arbitration or an international commercial arbitration, an application under section 8 or 45 will be filed. If it is a domestic arbitration, 8 to refer it to arbitration, 45 to refer it there. But if there is no suit, how? That's why my grievance is, here you are arresting my vessel and retaining and making me cough up security for an arbitration in which I am not even a party. And then, my lords, I am expected to, in my respectful submission, on legal principles, on equitable principles, my lord, the suit is not, the petition is not maintainable. In my respectful submission, my lords, these are the 4 grounds I had raised. I am extremely grateful, my lords, for my lords giving me this opportunity to address this court, my lords. Whatever, my lords, after hearing my friend, I'll, my lords, deal.
My lords, they said some.
First of all, why your pleadings are silent with regard to the proceedings that have taken place in Russia? Is it not the duty of your client to stay all these facts in the petition?
I will seek appropriate instructions on that. In fact, I was not aware of these Russian proceedings then. But also at the same
by way
time,
of a reply, you have filed the order of the appellate court.
now, my lords.
Now you have filed. Your client was prosecuting the matter. It is not about you aware of it. Your client was aware of it, which was not brought to the notice. Then what do you say about the maintainability of this petition without seeking a decree or a judgment and a decree, and simply seeking filing an application under 39? This is an application under 39.
It's an application under the Admiralty Act.
Admiralty Act. You will also quote a provision of the CPN. Interim relief is sought. You will
That's
say
my interlocutory.
under order 39, you will ask for the interim relief.
Please, my lords. On this Russia.
What is the claim that has to be decided by this court?
My lords, firstly, my lords asked them a very pertinent question. Now, what is your relationship with respondent number 3? There has been no answer to that. According to me, the respondent number 1 vessel was with the respondent number 3, which is why I took a time charter from them, and that was with them.
Ultimately,
So as far as the maritime-
even the arbitration, you're saying that pending arbitration proceedings, as the ship has to be arrested as a security to your claim. In that arbitration, is these people a party to that?
My lords, they are not a party to this proceeding either. They have come as a registered owner of the vessel. I have not made them a party.
My friend is wrong.
This is the party.
No, and the owners. It says so. Please see the cost title. What is my friend saying?
So my agreement is with the respondent number 3. There is no difficulty about that. And my arbitration is with the respondent number 3 because my claim is with the respondent number 3. Now I have sought arrest of the vessel because the respondent number 3 was in ownership of the vessel at the time of arrest. That is my contention. They do not say anything against that. Contrary to that, they have shown a report. What they have produced, that report, it is from 2018.
So
now, as
no,
on
the
date,
court.
It is a
No. Ultimately, this court will not adjudicate anything finally. This court will not be adjudicating anything. This court will only be arresting the vessel.
No, it must adjudicate on the arrest as well. And that is why, my lords, when they sought release, that order clearly notes that during final determination, let all contentions be decided.
What is the final content? What is the final relief you're seeking? Please tell the court.
Please, my lords, my final relief is to seek arrest of the vessel. That is there, my lords. That is how this Admiralty jurisdiction is, my lords. It is an action.
No, in Admiralty jurisdiction, if you say,
Please, my lords.
so-and-so owes me so-and-so money, now the ship is in the jurisdictional waters of this court, so please arrest the ship and decide my claim with regard to the so-and-so amount or so-and-so, but that's not your case here.
My lords, I could have never made such a prayer here because I had an arbitration clause and the agreement did not allow me to submit to the jurisdiction.
So now you
of
will
this
be keep
honorable
on,
court.
no,
The
you will be keep
jurisdiction of-
on making the same prayers in every country wherever the ship goes.
My lords, that appears to be the practice, at least even in India, that appears to be the practice where the petition is made for arrest. My lords, and humbly, the jurisdiction of this honorable court has only arisen because the ship came to the Mangalore port. Otherwise, the jurisdiction of this honorable court would not arise at all. My lords, my humble submission is that these contentions.
No, even forgetting about res judicata and other issues.
Please, my lords.
With regard to the same thing, you made a prayer before the court said Russia.
Please, my lords, yes.
And then the court said, initially order of arrest was made.
Order of arrest was not passed.
Was
That is
was
the-
passed or later
I'll
vacated?
show the page number where it is passed.
It was passed or later vacated?
Yes, my lords.
Vacated.
You're-
later
And
vacated,
again,
but
is that
later
you preferred an appeal? Again,
I
is
have
that you
preferred
preferred
an
an appeal?
I have preferred enough. If,
And that is such a crucial fact which needs to be brought to the notice of the court.
my lords, that
And
is-
just like that, making these kind of, averments which the complete pleadings without placing the complete pleadings before the court, coming up before the court, asking for what is the interim prayer, the court must have observed in case any of the facts are suppressed, or if it comes to the notice of the court that the order of arrest has been obtained, then you will be made to,
please, my lords, that is an undertaking that
where is that? First of all, you have to convince the court on the maintainability of this application with this prayer alone.
please, my lords.
Number one.
Yes.
Number two, about why your client has suppressed the material facts before the court. That's first of all, these two things have to be satisfied. And then, why were you repeatedly saying in your averments, at one place you say third respondent, first respondent is a owner. At some part, you say the third respondent is the owner.
Yes, my lords, I'll address my arguments, my lords, we posted to the next week. I'll address my arguments.
What
about
you
this
can
point.
do is,
My lord,
you can,
please.
or you can place before the court your written arguments.
I will.
And let them also respond to that. And again, we'll fix a date. That day, let her argue. And you also.
Can I do this only to assist the court, my lord, if it meets with the court? Let me hear my friend's argument. Then both of us, because then, my lord, I will be able to deal with her oral arguments. And one consolidated written submissions, both of us will prepare. So that, my lord, it will be easier for the court to, my lords, adjudicate. My friend will address on the next occasion, my lords. We'll try and be here. And, my lords, for my rejoinder, your lordships may keep a shorter date so that I can come address, and, my lords.
Just one more point.
Take that.
My lord, similarly, application to vacate arrest was filed.
Yes.
If my lord sees page 19, application under order 39, rule 4. 36, it is contended that there is no privity between the owner of the ship and the petitioner and that there was no privity between the two. Then on the next page, at the outset, it must be noticed that the contention raised is factual and a matter for trial. That is what has been said. Therefore,
Where do I do this trial?
my lord's admiralty rules are being formulated by this honorable court as we speak.
There's
There's a
nothing to
committee that will-
formulate in that.
Please, my lords.
There's nothing to be
I'll
formulated.
put my
No
point.
issues to be, there are no tribal issues in the suit.
Yes.
That's the whole thing.
I will point out, my lords, this judgment. I was luckily, my lords, this judgment was cited also before the Odisha High Court, where we were, my lords, arguing a vacating application. This was an application under Order 7, Rule 11, which your lordships, as your lordship knows, has to proceed on a demurrer. And therefore, you cannot take a position, move away
For
from
application.
this. This is an application under Section 5. And that's why, my lords, I was at pains to show. those provisions, I'll make my case good, my lords, when I deal with my friend's arguments.
Because now in this case, there is nothing to decide. There is nothing, we cannot say that all these issues will be decided in a trial.
Please, ma'am.
For that, we have to frame the issues. What are the issues to be decided by this court?
Please.
You don't want this court to decide anything. You don't want this court to arrest the ship and just keep quiet and see till your arbitral dispute. That is such a vague prayer you have made and it is
Please.
granted.
I'll convince.
No arbitration when it will conclude.
It is
Now, if you want the arrest of the ship and the subsequent proceedings also about the liability and other things, if this court is deciding, there is a timeline for that, isn't it? Now, this court will arrest the ship, somebody else will decide the claim. Till all those proceedings are decided, we will arrest the ship and keep it here. Heard the learned counsel appearing for the vacate petition. The respondent, learned counsel for the petitioner seeks time to advance arguments. When do you want it?
Does 27th suit the court, my lords?
27th. Thursday, how many matters? Leave order. Second is a holiday, April 2nd. But then we'll have it on first. First April.
Please, ma'am.
1st April at 2:30. Just keeping up.
We're extremely obliged, my lords, for taking this.
Yes, Mr. Call his case. This also keep it.
This is also password. List number 3, serial number 2.
Argue.
Password. R. Jaiprakash.
Lord, I'm not questioning the negligence of what, only liability.
Why,
But,
why the
accident-
court below held that the insurance company is not liable?
Pardon, ma'am?
Why the court held that you are appearing for the insurance company?
Yes, sir.
You are appearing for the claimant or the insurance company?
I'm appealing for the insurance company.
The trial court has held the insurance company is liable.
Yes, sir.
Why it is
I
not?
applied my contention that there's no driving license as of the date of accident. But still it foisted the liability on me. And I got 2 Supreme Court judgments directly.
Pay and recover is not ordered.
No, ma'am.
That's what you want.
My lord, now after 2019 amendment,
Still, we are holding the sentencing only.
I leave it to your lord.
We'll order that, please come to that point.
Your lordship may kindly see the exhibit R5, my lord.
Not R5, the judgment I need to look at, but the judgment is in Kannada.
Kannada, but only on document. Kindly see the exhibit R5.
No, it's not, I'll see R5. There is no difficulty. How will I dictate the judgment? Because I'm not well versed with Kannada.
Kindly permit me to file the judgment copy.
Whenever you file, we'll hear it. Post this matter as part heard. When do you want?
Lordship, kindly come done 2 weeks.
Post this matter after 2 weeks. By the time the counsel for the appellant shall file the translated copy of the judgment. Five and? Number 2.
Suresh M. Latur.
I am for the appellant, my lord, in all these
This is
cases.
number? Who appears for the respondent?
Respondent, it is B. Parameshwar. Palakshaya, B. Palakshaya.
It's not 5, I find something else. This is list number 2. 3, 5. Palakshaya, 8 is? Mr. O Mahesh, where is he? No representation for the respondent insurance company in both the matters. Both the matters.
Yes.
When do you want? When do you want?
Any date may be given.
Counsel for the appellant is present. list the matters on name. They're independent, don't have to close. Then passwords.
My lords, one submission with regard to serial number 9, list number 2, my lords, my presence may be noted, my
What
lords.
is that? List number 2, serial number?
List number 2,
Nine.
serial number?
9. I
Nine,
appear for the
no,
respondent
no.
number 2, I'm a formal party.
Oh, you're for R2.
R2.
Then some Pala, in his place you are appearing.
List number 2, serial number
Oh, you're appearing for R2.
R2, my lords, I'm a formal.
You can argue next time when the matter comes.
There's no argument, I'm a formal party. My presence may be noted, my lords.
Heard the counsel for the respondent number 2 present.